Good afternoon and welcome to the Appellate Division First Department. We have more than 6.5 hours of requested argument time. So as I go through the calendar, please ask for the time that you need, not the time that you want, so that I don't have to reduce your time for you. Please know that we are fully familiar with the briefs, the record, oftentimes more than you wish we were. And the clock is for you, not for my colleagues. So if you are brilliant in your argument and they have more questions, I let it roll. Okay? So don't get disturbed by my cutting of your time. All right. People versus William Anderson. Submitted. Goodson versus Steple Associates. Okay, do you wish to submit?
Just 1 minute.
1 minute, you got it. H. Seline versus Mark G. Okay, all right. Your appellant is not here. I'll give you 3 minutes, okay? Harjo Cod versus Tishman Construction.
4 and 1, please.
Okay. 4 and 1 and 3. Riverdale Jewish Center versus Con Edison. How much time?
7 and 2.
Okay. 5 and 1 and 5. Braggino versus Coachman Luxury. Submitted. Trout versus Basketball City.
Basketball City 6 and 1, Your Honor.
Okay.
Plaintiff respond in 5 minutes, Your Honor.
Okay. Okay. Do you have a cross appeal? Okay. Okay. All right. So BBC is 5 and 1. I can't remember the initials for the other. PPC? Yeah, Peer Productions is 3 and 1 as requested. Plaintiff is 5, and NGPI is 3 and 1. Okay? BDC Finance versus Barclays Bank.
Your Honor, we ask for 8 and 4. Respondent asked for 10.
All right, 7 and 1 and 7. Telefonica SA versus Milom International.
Appellate, Your Honor, 6 and 2.
Okay. All right, 6 and 2 and 7. S. Marquise versus Shantae is a submission. Brook versus Muser.
For the estate appellate, I request 8 and 3 minutes, Your Honor.
Yeah, so I request, I'm cross-petitioner pro se, and I'd like 2 and 2.
Okay.
I'm consulting court evaluator. I would write 4 minutes with regard to Adam Brook and 2 minutes with regard to the state.
Okay, we're doing it all together. I'm not separating the argument. So, 3 and 1 for the estate, 2 and 2 for pro se litigant, and 5 minutes for the court evaluator and others. Okay? 5 minutes in total. Port Morris versus Sangara LLC. 5 and 2? 5 and 2 and 4. Bank of New York versus Del Rio. Okay. Okay, let's do 5 and 1 and 4. People versus Justin Holmes Austin. Okay. 7 and 2 and 7. Pollock versus New York City Transit Authority and Meringue versus New York City Transit Authority. Submitted. Panzer versus Epstein. Okay. All right. This is an arbitration award. 5 and 1 and 5. Okay, first case on the calendar for argument, Goodson versus Steple and Associates. You may proceed.
Good afternoon, Your Honorable Justice. Your Honorable Justices, Edwin Kim on behalf of Plaintiff Appellant, and may it please the court. I'm not going to take too much of your time, particularly as respondent is not here. I just want to, most of my arguments were contained in the briefs. I just want to emphasize that this instant record is analogous to this court's holding of Aladali in 2021. This involves a non-delegable duty to maintain a safe means of ingress and egress. The plaintiff testified that he tripped on the door saddle that was uneven with respect to the ground of 1 to 2 inches. This is confirmed by an authenticated photograph contained in the record at 791 to 792 with
What case stands for the proposition that a door saddle is a structural part of a building?
In my reading of the law, I was not able to find a case of the actual structural component beneath the door saddle. Most of the law that I have discovered was the actual metal component of the door saddle. This particular case involves the misleveling of the door saddle by 1 to 2 inches. So,
I have found no case that says a door saddle is structural
well,
for the purposes of this analysis, so.
Your Honor, we have the only expert opinion of Robert Fuchs contained in the record that confirms that the component underneath the metal door saddle is a structural component relating back to the redesign of 2012, and it's violative of the 1968 building code and the 2008 building code in being a threshold in excess of 1 to 2 inches.
Okay, so what about the fact that the defendant was an out-of-possession landlord, one, and the fact also that the prior tenant was the one who constructed this door saddle, or whatever you want to call it, and the fact that the lease stated that you were taking it as is?
I will first begin with reemphasize that it's a non-delegable duty to maintain a safe means of ingress and egress, as this court held in Aladali. The lease does not relinquish control of
The lease also states that you have, that the defendant had no duty to maintain, right?
no duty to maintain the demised premises. When we're talking about the 1 to 2.
Okay, what about the fact that you took it as is?
I'm sorry?
What about the fact that you took the property as is
With
with the existing door saddle?
the complaint of defect is a structural violation of 1 to 2 inches beneath the actual leasehold, beneath the premises. Yes, you took the premises as is, but we're not talking about a component. We're talking about a structural component underneath the actual door saddle, which would be part of the demised premises. It is a structural.
I find it curious how a out-of-possession landlord would be able to have notice of a structural defect underneath the top surface of the door saddle.
Thank you, Your Honor. That was part of the third question of your colleague that I meant to answer.
You have 30
He
seconds.
was there. He testified. He was there every 6 weeks since 2012 doing inspections. He conceded he never conducted an inspection
Counsel,
to ensure that.
I don't know about you, I don't know anybody who picks up and tears off the overcovering of a door saddle to see what the condition of the frame of a door is. But I got your argument. Thank you very much.
Thank you, counsel.
Harjo Cod versus Tishman Construction.
I mean, you get Seline.
Huh?
Counsel for respondent for the Seline versus Mark.
Oh, I'm sorry.
My name's Daniel Rubens. I'm with.
Were you here? You weren't
Yes,
in the,
my colleague will be presenting argument with your permission. He's admitted pro hoc vice, so I just wanted to request the.
oh, I see. Okay.
So my colleague Nicholas Gonzalez will argue.
All right. Granted.
Good afternoon, Your Honors, and may it please the court. My name is Nicholas Gonzalez. I'm with the law firm of Orrick, Harrington, and Sutcliffe, and I represent the respondent in this appeal. This court should affirm the 5-year protective order. Appellant's arguments on appeal are nothing more than an effort to relitigate the factual and credibility determinations that the family court made. But to,
Did it in a 37-page decision, correct?
correct, Your Honor. And it was very well reasoned, and she cited many pieces of record evidence that showed that the appellant posed a danger to her and continued to pose a danger to my client as recently as the trial, which occurred in 2023. At the trial, he continued to demonstrate an obsessiveness towards her. He continued to demonstrate that he viewed the idea of joint suicide in a romantic way and did not
You
take...
had to file a violation petition as well, correct?
She did file a violation petition, and that was because at the earliest opportunity, when he thought that the temporary order of protection no longer applied, he, at that opportunity, jumped at that opportunity to reach out to her. And that again demonstrated that he continued to be very obsessive towards her and that he continued to pose a danger. I would just point out that despite her repeated efforts to tell him to stop contacting her, he did not take no for an answer. He showed up at her apartment and he physically assaulted her. He also sent her disturbing messages, which suggested that they should commit suicide together. And he sent her emails incessantly, even after she told him to please stop contacting her. For all those reasons, the evidence in the record supports the family court's conclusions, and appellant has failed to carry his burden of showing that those findings were, quote, that were clearly unsupported by the record. So we would ask that this court please affirm.
Thank you. Harjo Cod versus Tishman. Sorry about that. You may proceed. Thank you.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff appellant. In this case, it's our position the trial court erred in denying summary judgment as premature. There is no discovery that the defendant set forth
How
that
about the EBT of her colleague, Mr. Lopez? No, it was the person who was in the same basket in which she was allegedly ejected from.
Well, our position is that with respect to, I mean, they could have put in an affidavit from Mr. Lopez in opposition to dispute the plaintiff's statement, plaintiff's affidavit, the affidavit of the coworkers, the Department of Building violations, and I think what's really telling is the affidavit from Mr. Cohn from Tishman, which is at 855 of the record, which discusses what the violation was and how they were going to remedy it. So in opposition to summary judgment, they could have put in something from Mr. Lopez. They didn't put in anything, and just the mere hope that something will come forward in discovery, as you know, isn't a basis for 3212F. And here, I mean, you see the photograph at 175 of the record. I mean, it shows her dangling 80 feet above ground. She was I think it really just speaks for
Counsel, so your adversary didn't put any affidavit to refute the mechanism of how the accident was established by your client? There's nothing there?
There's nothing in the record. There was nothing in opposition that was put in. And so he had the opportunity to do so. It's a perfect example of where summary, where a case should be.
Was there even a suggestion about what might be adduced through discovery that could save them here?
Not that I've seen, which is really the basis for granting summary judgment, even before depositions, as this court has held in Blasio, which is in our brief. This is a perfect example of where the issues can be narrowed, and it should go to trial and damages. And as I said, they've had the opportunity. They didn't put anything in, and at this point, it's undisputed that there's 2 violations, not just one. She was ejected, and the harness didn't work, as you see from our brief. So, if no further questions, I'll take anything else in reply.
Thank you.
Thank you.
May it please the court, Brian Morrissey for respondents. What my office did do in opposition to the motion was to enter into a discovery stipulation that was so ordered by the IAS judge 1 week before the order denying this motion was issued. This case was handled by the same judge from the inception.
That doesn't address the substantive issues we've been discussing. So why don't we discuss that? Tell me what in the record there is that might suggest that discovery would be helpful in any way on this case.
Number one would be the harness, Your Honor.
I'm sorry?
Number one would be the harness.
What about it?
An inspection of whether it worked, whose it was, and how it was used.
Whose obligation was it to make sure that the harness was, one, provided and properly working? Hers or her employers and the defendants here?
Obviously, the duty rests with the owner, but it was her personal harness.
Does that matter?
In this case, it does
seems
matter
to me,
because we should.
It seems to me that a thank you should be given to her for her wearing a harness. Because if not, we'd be here on a wrongful death case.
There's no doubt that the picture depicts somebody in extremis, Your Honor, but an accident.
I'm sorry, the pictures depict what?
Somebody in extremis. She's in the.
She's dangling. I forget how many
Yes,
feet
I
off
understand that.
off the ground.
That is not summary judgment in and of itself. Don't we need to find out how the boom was operated, how the colleague operated?
Well, we know that the boom was not operated properly, but that's not her fault. So again,
How do we know that? though?
again, she
do we-
wasn't operating the boom, right?
Well,
And the evidence in the record is that whoever was operating the boom hit the scaffold, or it got hooked onto the scaffold, and in trying to loosen,
all of that was really unclear in the record. It was not, there was no indication of how the boom came into contact with that. The person.
again, how would that matter vis-a-vis the plaintiff who is inside and
Because
had nothing to do with the operation
we
of
have
the-
not had a chance to explore, which we are entitled to, whether the plaintiff, our only defense is that she was the sole proximate cause of it.
You do-
How is she the self?
But
But please,
But how
please,
can we rule
please
that
tell
out
us. Please,
on the basis
I'm
of one
so
picture?
curious. And how would she be the sole proximate cause of this?
that would be speculation on my part. I think we need.
No,
to
not,
get-
not
no.
just speculation. That statement defies the record we have. There is no way on this record that she can be considered the sole proximate cause, if for no other reason that she was ejected from the bucket she was in.
I'm not asking
That
you to
is-
speculate. You just made a statement. You're arguing that she may well have been the sole proximate cause. So what I'm trying to, I don't want speculation. We're not asking for speculation. What is there in the record, or what discovery would you, would be required, or would you need to show that somehow she ejected herself from the bucket and she decided that she was going to be an aerialist and dangle, I forget how many feet from the ground. Oh, wow, it looks so great. Let me just dangle from the ground. Where is that in the record, and what discovery would that be? Is she a former aerialist? Has she done this in the past, where she decided she was going to fly around? I mean, I'm trying to
We wouldn't
curious.
question her about circus activities. We would question her about the operation of the boom, and we would
We
question the
know
operator.
that the
of the
boom was hooked on the scaffolding, causing her to be ejected.
That's her supposition. as
Not
well.
just her supposition. There are affidavits from other co-workers who say exactly the same thing. And in opposition, we have nothing.
But we do have a court order saying that the plaintiff should be
that's-
deposed. Are we going to
That's
ignore
why
the
we're
court
here,
order?
to decide whether that was proper or not.
Why are court orders entered into?
Counsel, you don't get to ask the court questions. That's not how
I
this
submit
works.
that the
Thank
court.
you.
Thank you.
Just two quick things. We know that under Blake and its.
Sir, the argument is not over. She still gets 1 minute, okay?
I could take less. As we know, under Blake and its progeny, plaintiff can't be the sole proximate cause when there's a statutory violation. But if you look at 856 of the record, what I think is The most devastating to the defendants is the Tishman affidavit from Mr. Cohn that references the violation of failure to institute and maintain safety equipment. And he says the following: at the time of my inspection, responding to an incident where a worker was injured using a boom lift, hanging plastic on a scaffolding that was behind the plastic when the boom lift got stuck on the scaffolding and the worker got ejected from the boom lift. There's really nothing else to say.
Thank you.
Thank you.
Riverdale Jewish Center versus Con Edison. You may proceed.
Good afternoon, and may it please the court. Gung Chen from Sussman Godfrey for Plaintiff Appellant, Riverdale Jewish Center. This case concerns an affirmative misrepresentation specifically targeted at religious institutions and other nonprofit customers of defendant Con Ed. The plaintiff purchases gas service from Con Ed, and in 2020 alone.
Counsel, this is a provident exercise of discretion standard of review, right?
Correct.
So how is this an abuse of discretion?
Frankly, Your Honor, the motion court did not make any findings that would justify the application of the primary jurisdiction doctrine. While the motion court discussed what the doctrine was, the motion court did not identify any specific need for agency expertise, nor did the motion court identify any specific PSC decision, determination, statute, or regulation that would be affected by this
Should we worry
case.
about inconsistent adjudications shouldn't it be sent initially to the agency for determination so that they're not inconsistent determinations by courts vis-a-vis the agency?
Your Honor, I don't believe that there is any risk of an inconsistent adjudication. As my colleague admitted and conceded at the motion court, the PSC cannot adjudicate GBL 349 claims.
So why shouldn't they be allowed to do so in the first instance?
If the PSC cannot adjudicate GBL 349 claims, and that claim must be heard within the court, there is no primary jurisdiction at the PSC. The primary jurisdiction applies only when there is concurrent jurisdiction between the agencies and the courts. In this case, there is not concurrent jurisdiction.
Continue.
And on the issue of agency expertise, I just wanted to mention that Riverdale paid $2,000 more on the residential rate for gas than it would have on the non-residential rate in 2020. It was able to calculate this figure by simply multiplying its actual gas usage as provided to it on its monthly gas bills by Con Ed's non-residential rate, and then compare it to what it actually paid on the residential rate. This same basic math could easily be done for all of Con Ed's Section 76 customers for gas service using the customer usage data in Con Ed's possession.
So you're arguing, therefore, that in doing so, the defendant's representation caused you to adhere to a higher rate assessment and a higher rate. Is that correct?
The defendant's misrepresentation, correct, caused the Section 76 customers on gas service, like Riverdale, to pay more using the residential rate for gas service than the non-residential.
Exactly.
But they had a choice, right?
But given that, would that not invoke the primary jurisdiction doctrine?
This is a simple misrepresentation case, Your Honor, just like every other GBL 349 case. Whether the statement was a misrepresentation, that is something within the conventional experience of judges and juries. Whether what the damages would be if the misrepresentation occurred, again, that's a simple calculation, as I've just described, within the conventional experience of judges and juries. There is simply no actual technical issue here for the PSC.
Well, yeah, you're claiming that there's a higher assessment rate. Why would that not why would that not mean that they should make the determination as to the assessment rate, et cetera?
Both of those rates, Your Honor, are published in Con Ed's tariff. There's no dispute as to what that rate actually is. It's a simple math question at this point as to how much the customers themselves paid using usage data within Con Ed's possession, not within the PSC's. The PSC does not have the information to actually do this analysis. That kind of information can be produced in discovery in a court proceeding, and then the analysis can be done as it is in all civil cases.
Did the statement in the pamphlet dictate what your client should do?
Excuse me, Your Honor?
Did the statement that you say is a misrepresentation dictate what your client should do and what rate they should select?
It didn't dictate
It
to
didn't,
the
right?
customers
Because in
what they
fact, what it said was religious institutions, veterans and organizations, and some community residences have the choice of being billed under either residential or non-residential rates. While residential rates are more economical for most customers, non-residential rates can be more favorable for certain customers.
That's correct, Your Honor.
How was that a misrepresentation that caused your client to choose one over the other?
The misrepresentation is in that phrase, while residential rates are more economical for most customers. That sentence was targeted at customers already on the residential rates. It told them that the rate that they were already on was more economical. If that was not true, and if they have not been told that the rate was more economical for most customers, they might well have chosen the different rate.
And we can discern that just based on what? You're saying so? They're arguing so?
Like in all GBL 349 cases, Your Honor, whether something is a misrepresentation, whether it was material.
But what's the misrepresentation here? Are you saying that under no circumstances can that last statement be true? There's never a circumstance where non-residential rates may be more favorable?
That's not what I'm saying, Your Honor.
No, but that's what the statement says. So if you're saying that that statement is a misrepresentation, then a part of that statement has to be false. Which part is false?
That residential rates are more economical for most customers. They are not. They are not more economical.
So residential rates are never, is what you're stating, therefore, is that residential rates are never more economical.
No, I'm simply stating that residential rates
says are
more economical for most, as
for
in
most,
more than half.
exactly. So most, right? So
if
your argument would be that you can't say that most. It would have to be. It's never economical.
No, it's just that it is not most. If it's just a few
it's not most, then
residential-
what
if it's
is
just
it?
a few
How are you assessing that?
Where do you get the support for that statement that it's false, that most don't benefit from the residential rate?
There are certainly findings, as we discussed in the complaint, from the AG's investigation, but also, Your Honor, at this early juncture, that allegation must be taken as true. It is pleaded in the complaint, and it must be taken as true in
And
plaintiff's
also, I think
favor.
another thing is that in addition to this, to the part of the pamphlet that was just read to you, you have that subsequent section that says the non-residential rates can be more favorable for certain customers. Wouldn't that put your client on notice that maybe for them they fall into that second part?
It certainly puts some on notice that there might be some customers for whom the non-residential rate is more favorable. But as a proposition for all customers, most of them would think.
But they're not all customers. You're telling me that they're making decisions about what rate they choose based on what's good for everybody or what's good for them?
They certainly need to make those decisions based on what's good for
I
them.
want to hear you say, if your argument is that they consider what's good for everybody, I want to hear you say that.
I think if you're told as a customer that for most
Counsel,
customers like you,
I've asked you a question and I need an answer. Okay? Are you saying that your client relied on that last statement because they were deciding which rate to choose based on what's good for everybody around them or what was good for them?
well, certainly the decision they make has to do with their own usage and their
Right,
own
and that's
bills.
really the only consideration they have, what's good for them.
But if you as a customer are told,
Counsel, I'm saying the decision of what rate they choose is based solely on what rate is good for them.
So I would disagree in that they can, if they are told that most customers like you benefit from the residential rate, then that is certainly a fact that they could consider. If they were told that most customers like you do not benefit from the residential rate, that would make them more likely to choose the non-residential rate. That is the misrepresentation at issue
Because they make
here.
no assessment for themselves of what that means for them.
Knowing that other customers like you
That's what
benefit
you're saying.
in certain circumstances does impact what you think might be better for you.
Okay.
Thank you, Your Honor.
Good afternoon, Your Honors. Frances Bivens from Davis Polk and Wardwell on behalf of Respondent Con Edison.
Why on earth would they muddy the waters in this way?
Well, Your Honor, that's a question either for the Public Service Commission or the court. And what this court is here to decide is which one of those entities is actually appropriate for making that determination. And what I would posit is that in this circumstance, this is not a case where, under the GBL, there's just an assessment of a single statement. Appellants would have this court believe that all that needs to happen here is just an analysis of whether a particular sentence itself is misleading. But what New York law requires under the GBL is for there to be an assessment of whether the appellants were in fact misled by that statement. And what is in fact required.
Counsel, there was an Article 78 involving the Archdiocese of New York, right?
That's right.
Concerning a similar issue.
That's right.
The exact same issue, actually. And what's the status of that? Was there an appeal of that trial decision?
So that decision, actually, it's in the record. It went back down to the Public Service Commission, and the Public Service Commission actually rendered a final determination. And the final determination resulted in a certain refund being granted for a very limited period of time, which points up another reason why the Public Service Commission is the right place for this. That Archdiocese case involved a claim by religious customers about a billing insert being misleading in a very analogous circumstance to this one. And what that case shows is that there was a hearing officer assigned who looked at the whole panoply of information that was available to religious customers in the publicly filed tariff that the religious customers are, as a matter of law, deemed to have notice of. This billing insert in particular refers specifically to the tariff and refers the customers to go consult the tariff. It also provides them with access to a helpline in the same billing insert that's being deemed and argued to be misleading here. It's the Public Service Commission that oversees the issuance of that billing insert.
Also,
It's done.
the Attorney General conducted an investigation into Con Edison that ended in 1994, right? And as part of that, there was an assurance in which the parties agreed to the following. Con Edison's religious rates for gas service are not advantageous to customers, even at very low levels of consumption. Essentially, a customer is better off paying Con Edison's commercial rates for gas if the customer uses gas for anything other than moderate amounts of cooking. When you take that assurance that was agreed upon by the parties and you compare that to the statement, while residential rates are more economical for most, doesn't that render that statement in the pamphlet misleading?
So first of all, Your Honor, that was 30 years ago, and so there's no evidence in the record that the rates that were being considered at the time are the same as the rates that are in application today, and so there would have to be a reassessment of that issue. The other thing is that this billing insert was specifically targeted at steam, electric, and gas altogether. There was no specific reference as to which type of utility service was being described by that statement. And appellants have conceded that in the context of electricity, that statement is actually true. Residential rates are almost uniformly more advantageous for religious customers. The only question is what the circumstance is for gas. I don't know the answer, Your Honor, and that would have to be determined by either a court or the Public Service Commission. But I would posit to the court that it was not an abuse of discretion for Justice Chan to decide that it's for the Public Service Commission to make that kind of determination.
In the first instance?
In the first instance. And then, of course, it's not that the courthouse doors are closed to the appellants. They just need to go to the Public Service Commission first, where the expertise of the Public Service Commission can be brought to bear, both in assessing, as Your Honor has pointed out, the truthfulness or lack of truthfulness of the statement, but also what remedy is appropriate. And so in the Archdiocese case, the petitioner in that case had sought a decade's worth of rate refunds. What was actually granted was several months' worth, and that kind of assessment would need to be made here. The appellants have claimed for 30 years of rate refunds in this matter, even though the billing insert they complain about has only been in circulation since 2020. So there would need to be a determination of what would be an appropriate remedy if one was deserved. And they've also asked for class-wide relief in joining or instructing Con Edison to move every religious customer from the residential rate to the non-residential rate without any kind of individualized determination as to whether that would be appropriate for any of those customers.
But that's not what is being requested here. So why could the court not make the same analysis, and why could the court not also have a hearing officer to go through the assessments, et cetera, the same as the Public Service Commission.
One of the most critical pieces of evidence here is what is stated in the tariff. The Public Service Commission has primary, not just primary, but it has unique jurisdiction over the tariff. It actually approves the tariff language. And one piece of evidence here that was also at issue in the Archdiocese case, but is going to be at issue here, is whether, by reading the tariff, the appellants actually would have been put on notice that they were in the position of having to analyze for themselves whether the residential or the non-residential rate was actually appropriate for
And the
them.
court could not make the same determination?
It's that the case law is very clear in New York that where tariff interpretation is at issue, the Public Service Commission is the appropriate first stop for that kind of an analysis.
Thank you.
Thank you.
You have a minute?
Thank you, Your Honor. Just very quickly, one key point in this case is that plaintiff brings a claim under GBL 349. The standard under that claim is whether a misrepresentation is likely to mislead an ordinary reasonable consumer acting reasonably. The PSC is not an ordinary reasonable consumer. It cannot put itself in the shoes of that
What
reasonable
about your friend's last statements concerning the Public Service Commission's sole purview over determining the tariffs?
The tariff language that was discussed in the briefing, Your Honor, has nothing to do with plaintiff's claim. We do not allege that it is misleading. We do not allege that it formed part of the residential insert. I think what my friend is saying is that that language must be determined in its totality.
I thought, again, your argument was that because of the misrepresentation, you were caused to pay more than you should have paid.
That's correct, Your Honor.
So then why, again, are we not talking about the tariff?
Because the statement in the tariff concerning the residential versus non-residential rate is not the statement that we allege is misleading. The statement we allege is misleading was not in the tariff, has never been in the tariff. It's in an insert that Con Ed sends to its customers on an annual basis and continues to do so to this day.
Thank you.
Thank you.
Trout versus Basketball City.
May it please the court, good afternoon, William O'Connell for the defendant appellant Basketball City. There's a quick procedural question in this case, and it had to do with my cross motion. The plaintiff moved for summary judgment right after the plaintiff testified, and we cross moved. However, on the e-filing system, our motion was made a cross motion to plaintiff's motion to amend his complaint.
This seems like a total, to me anyway, I can't speak for everybody else, but it seemed like a complete kerfuffle. It was just, it not prejudiced anyone else. So I'd move on to the merits.
Okay, fair enough. And that's my argument here.
That's my opinion.
Excuse me, just one second. The issue here obviously is covered work. It's our position that the plaintiff was not engaged in covered work. The Supreme Court held that it was covered work because the plaintiff was assembling audio equipment for the drum riser, which was an integral step in constructing the drum riser. But the drum riser was already, and plaintiff concedes that in his brief, the drum riser was already constructed.
But that's not the only thing he was doing on that day, right?
Well, that's the allegation.
And in fact, in his EBT, he talks about the other things he was doing on that day.
He does. And
he talks about having helped some of the carpenters install a piece of decking. They added a piece of staging. I can't recall what part of the stage. I remember we call it humping. After you install the scaffolding, humping a piece of stage, decking, and get it onto the post. I did a little bit of everything. I touched a piece of every department that day.
Well, it sounds like he covered everything, but the two things that he did mention were the humping of the stage, excuse the expression, and the installation of speakers while on a genie lift. That both involve installation. He uses the word installation in his description, and installation of these parts, and under First and Second Department law, has consistently been deemed non-covered work, particularly where they're assembling and
So
building.
his participation in helping create and extend the stage, in your mind, is not construction?
Not if it's, in his words, installing or humping part of that stage. It is not. But there's other evidence in this case. Plaintiff testified that the whole place looked like a construction site and nothing was completed. But then he was asked what he saw in the room when he came in, and he said the stage to the right and the left, lighting hanging off trusses, speakers across the entire room, black velvet curtains, lots of cabling and video screens, all of which were already set up. So it sounds to me like it was almost, and the show was the next day. So it had to have been.
That is meaningless, because we know that stages for performances like this are being set up until hours before the performance hits the stage. So the fact that it was the day before doesn't really lend anything to your argument.
Your Honor, okay, I disagree, but you expected I would. The plaintiff was asked what other work was going on while he looked for audio cables, which was what at the time of the accident.
Now, doesn't our case law say that we don't analyze in this strict little time frame that at the moment of the incident was he actually involved? We've actually held, in the case of Rukowski from 2017, where the plaintiff was removing furniture from an exhibition booth, but it was part of breaking down that entire exhibition, and we held that that was within the purview of 240. So why is this not similar in that here the stage wasn't even finished, so it's different from some of the cases that were cited by the defense, and he participated in some of the construction of the stage just before this accident.
Again, we believe his participation would not qualify, but also in Royce, in this first department, also held that moving audiovisual, staging, and lighting equipment into a hotel ballroom, assembling and setting up that equipment, and removing it after the event did not constitute covered work. So there may be...
Yeah, that was just lighting. That didn't involve creating stages or anything.
It said audiovisual staging equipment. That's separate from
Audiovisual
lighting.
staging means pointing it at particular spots.
Could be, also means part of a stage, which is the way I took it. But in any event, there are several cases in the first department that discuss moving, installing. There's one installing a hoist motor. You know, that could sound arguably construction related. That case, non-covered work. Also, plaintiff relies heavily on witness Vargo's testimony that the stage was in the process of being built when the accident happened. But earlier in his deposition, Mr. Vargo testified he was not on site, he was not in the state of New York, and he was not an eyewitness to any of these events that he's testifying about. So really, that doesn't add anything to the case.
Okay, thank you. The light is on, you'll have time on rebuttal.
Understood, Your Honor. Thank you.
Who's next?
Good afternoon. I don't really have too much to add. Essentially, I represent Peer Productions, the third-party defendant employer. I really don't have anything to add beyond what counsel's already stated. I know you've read the brief. You know, we believe that this is a situation where there has to be a natural endpoint to where Labor Law 240 can apply. I think that...
See, but part of the problem is when you have a audiovisual employee who you then farm out to other departments on site at your will, now you open the door to exactly what we have here. You can't pick and choose when he's involved in construction and not construction, right? So once you say, now participate in construction, if on the day that he gets hurt, he's participated in construction, you've created a problem.
Well, I think that the record that was presented before the Supreme Court, Your Honor, certainly raised questions of fact as to what was going on that day. And I would submit that those questions did not necessarily warrant a grant of summary judgment on 240 in plaintiff's favor. I think that there was enough evidence there for the court to find a question of fact, should have found a question of fact on this issue. And I rest on my brief with respect to the other arguments.
Thank you.
Good afternoon, Your Honors. I'm Judy Shamitzi with Wilson Elster for Viacom and New Games. I do agree with my colleagues that there are questions of fact here with respect to the extent of the work, and that is because the test for the application for 240 would be whether there was a significant physical change. And I do think that that has not been established here. Even if he did some construction, the test would require that he would make a significant change to the existing structure. And none
We've
of the
had
tests-
changes to a banner constitute enough. So how is creating and expanding a stage, how does that not qualify?
Well, he's certainly not creating the stage. And I think that.
Well, the crew was creating a stage.
The carpentry crew. Sure.
Right.
Your Honor, all.
That he was helping that day. I read you the transcript.
Yes, Your Honor. All I am suggesting, Your Honor, is that there is a question of fact about whether the work that he did that day was a significant change. And I do agree, of course, Your Honor, that what is going to be significant is going to depend on the scope of the project as a whole. So a smaller project, a smaller change will qualify, but a larger project overall, I think in order to make a significant change in that, there's no question that the stage is basically up. So whether what they're adding now is significant or not, I respectfully submit is a question of fact. I did want to touch very.
Is there any case that holds that? That if on day one when we start the building, that clearly would be a day as you're starting to build, there's significant changes going on. But is there a case that says when you're at the end of constructing of the building, if that last piece of sheetrock has to go in, since it's insignificant change, that's not enough?
I didn't mean to suggest that, Your
Okay.
Honor. I'm saying that, for example, in Royce, right, it depends, the significant portion of the test depends on what the project is at hand. So, which is why I can envision a case in which the work that was done in Royce would qualify, but it didn't in Royce. And the reason for that is because it didn't make the significant part of the test. And if I may, very quickly on
You still have time.
on the issues for, I wanted to just once be done earlier. On the new games issue, I just simply wanted to say that there are also questions of fact with respect to who controlled the site, who made the decisions about when and what would be installed, and ultimately who had the authority to make decisions about that. And for that reason, the common law indemnification, which is just such a, it's a delicate thing, right? You really have to be in the right box. And I do respectfully suggest, Your Honor, that on this record, there remain questions of fact on that issue.
Thank you.
Otherwise, I rest on my brief. Thank you.
All right.
Thomas Cassione for plaintiff respondent Mark Trout. Quick point, not a wire, not a cord, audio cable. In their briefs, my various adversaries try to minimize what was going on there. In the record at 1293, there's a picture of an exemplar drum stand that's a very complicated, elaborate cabling that has to be done. That drum riser was part of the stage. It's in the schematics. They built it off stage. Also, there's a few statements in here that the carpentry team built it. No one ever testified to that. Mark Trout said, we built it off stage. And they were still in the process of building it. Building it, you put the wheels on it, you get the platform together, you wire it up. That's part of building it before they muscle it up onto the stage and then they hook it into the audio system. If he was the last one up there plugging in the microphone to power it up on the stage, maybe I'd have a different argument.
Well, that was Royce. It was like changing the color of the lighting or something. It's putting gel or something on.
In
it.
Adair, yeah, they after the fact they decided they had to soften the lighting. They
Right,
put gel on
exactly.
it.
Yeah.
That's kind of a pretty trivial.
Well, so that's why the court stated that it wasn't significant.
Now, also, everyone testified that the construction was ongoing at the time. Nobody said anything different. Mr. Vargo, who you would think would be in the interest of not saying it was under construction, said it was. And, later on, during the pendency of this case, we took more depositions and nobody disagreed with Mr. Vargo. It was under construction. What Mr. Trout did, as we said, as Your Honor said, that he worked in construction work that day, putting wood up onto the stage, humping it or dragging in a big wooden panel is certainly construction. Building that drum riser is construction. Bringing it up onto the stage to secure it on stage where it's part of the schematic is construction. I don't really see where there's any issue of fact. Nobody disagreed with any of these basic statements whatsoever. So essentially, Your Honor, he's entitled to protection under the labor law. I think the problem that some of my adversaries had, because they work in more traditional construction cases where the electrician only does electricity, the plumber does plumbing, the laborers clean up, everybody has a defined role and they don't step outside it. Stagehands are a little bit of everything. They have to, every stagehand is a carpenter. To an extent, every stagehand is an electrician. Every stagehand is a rigger. In fact, when they step out, when they go beyond their training,
Not a carpenter in a professional sense. They help out the carpentry department, right?
Yes.
Okay.
The new case, the most recent case was Andino, and that was, I guess, an inexperienced stagehand that unfortunately tried to act as a rigger and clipped onto the wrong device. She used a plastic clip instead of the metal one that holds your harness, and she fell down. It was sad, but they said hanging a banner is not construction, and I would agree. This case is, and I think the facts are very simple. Thank you very much.
Your Honor, counsel seems to discuss stagehands. This court has ample experience with stagehands. And in Royce, Andino, Adair, and the Second Department, and Travers, Holler, and Leos addressed very similar questions and found that it was covered work. So I think Your Honors know the issues in this case. The drum riser, plaintiff admitted in his brief that it was already built, so he goes on about how it's not finished yet, but that's not what he said in his brief, so I'm going to take him what he said in his brief. And the pictures of cord and cables.
Well, we know.
Yes.
To be fair, though.
Yes.
This drum riser was so that Bieber could perform on it the next day, correct?
That's my understanding.
And the photograph of this drum riser, once completed, shows a very intricate web of cables that go in and up through every single drum on that drum riser, correct?
Yeah.
And it's a huge surface. This isn't a small space. It's, if I'm reading the photograph correctly, 12 by 8. That's almost the size of a bedroom in some places, right?
Yeah.
Okay, all right.
Yeah, it's obviously our position that, again, the type of activity we're talking about. He was in the audio team. He was plugging in cables into speakers. That's what he was doing.
Oh, come on. That's
not what he was doing?
Plug it. You see, you're making it seem like all he had to do was plug it into the outlet.
He had to plug in multiple things into
he had to wrap an entire system around a stage. That is not just plugging it into speakers.
But in terms of the labor law, I don't see the difference, Your Honor.
Okay.
With respect, thank you. I think we're done.
You still have more time, right?
Yes, I do. Okay.
I don't want to make that mistake. I do that often enough.
Thank you, Your Honor. Just again, I think the record is replete with evidence that should have been considered by the Supreme Court to find a question of fact as to what exactly was going on that day. I don't think that it's clear on this record as to what was happening, what was transpiring, and so I think that the Supreme Court should have denied the request for 240 in plaintiff's favor and preserved it as a question of fact for trial. In regards to...
So the plaintiff was deposed?
Yes.
And so what was put in to the record to counter what the plaintiff testified to as to what he was doing on that particular day?
So, well, in terms of where the phase of the work, where it was at that point...
no, meaning did you put in affidavits of the many stagehands and other workers who were on site clearly to get this stage ready for tomorrow's concert?
So
Any affidavits?
There was an affidavit. We have an affidavit that was submitted as part of my papers in regards to the phase of the work at that point and where the stage was in terms of how it was constructed. I mean, there was testimony that the lights were being tested. Certainly, the lights could not have been tested if the stage had not been constructed to where it needed to be.
Why?
Why?
Because they need to assess how the lights are going to appear on the stage.
Is that in the affidavit?
That was the testimony. The testimony from Mr. Trout himself was that lighting testing was going on.
Right, but again, he also testified as to other things that he was doing. And so my question was there any affidavit by anyone saying that it wasn't necessary for him to do these things because everything was ready for Beaver the following day, or that he actually wasn't doing these things?
So the affidavit from Peer Productions foreman, I think certainly raises questions of fact as to what you're addressing, Your Honor. And the testimony
But
from
that affidavit only spoke to the phase of the construction. It did not talk about what the plaintiff was or was not doing.
So the other testimony I would point to, Your Honor, is the testimony from the witness who was produced on behalf of New Games. They had 50 production leads, or perhaps even more. The number escapes me off the top of my head, but they were the ones who were essentially directing what was going to be happening that day, and certainly they could not have been asking for testing to be done if there hadn't been a level of completion that was needed in order to do that testing.
You're asking us to make assumptions based on facts that are, I don't know, it seems a bit of a leap.
Well, I just think that on this record, certainly it presents a question of fact on the very issues that we're talking about today.
All right. You have a minute. Thank you. Okay. BDC Finance versus Barclays Bank.
Whenever you're ready.
May it please the court, Jeff Zager for BDC Finance. Your Honors, BDC's complaint includes an alternative claim that if BDC was the defaulting party under the party's ISNA agreement, that Barclays still unreasonably calculated its loss.
Right. Supreme Court ruled that you waive that right to recovery by not appealing Judge Branson's decision about Phase 1 and Phase 2, right? That's what she held. And you disagree, and you disagree with
that decision, Your Honor. That was the issue that was up here on appeal.
And we knew that that Justice Branson had done that when we issued our prior appeal remitting the case to Supreme Court, right?
That's correct. The issue was front and center. That case management order had already been entered. We had Phase 1, which was about BDC's collateral call. We had Phase 2, which was about Barclays' collateral call. The next issue was always going to be the measure of damages, as Justice Branson laid it out carefully in that case management order. So this alternative claim, 57F, the $125 million issue, was always in this case, Your Honor. And that was...
It would have gone away if Phase 1 had gone a different way, right? Possibly? Your claim?
If Phase 1 had been won by BDC on BDC's collateral call, that's absolutely right. It would have mooted the issue, because the gating issue is who is the non-defaulting party with respect to who gets to calculate the loss calculation. So again, Phase 1 was about BDC's collateral call to Barclays.
Yeah.
Phase 2 was Barclays defaulted. It's a gating issue.
And you lost in Phase 1, and so you went on to, we're going on to Phase 2, or that was what you were contemplating.
Correct. We had Phase 1. Yeah. We went on to Phase 2, Justice Moulton.
And I was on that panel, and I kind of thought that was what was going to happen next, frankly.
That's what we all thought.
Which does not bind any of us, but that's what I thought we were contemplating, so I was surprised to read the decision.
We got to the scheduling order, and all of a sudden, for the first time, Mr. Scott was here at that argument. He heard the $125 million issue, and he pretended that the argument about that $125 million all of a sudden didn't exist, and starts re-arguing the issue of the case management order. Just so it's clear for all the panel, I know Justice Moulton was here, but there's been some selective quotation of Justice Branson's case management order. And I want to be perfectly clear what she said. I think Justice Moulton knows. She says, quote, "I think that in order to do this properly, you would have to do the first portion. And if there's a finding that Barclays did not default, then two things happen. The next issue is the counterclaim. Should Barclays win on that, then of course it would be the measure of damages. This trial structure tracks how the parties' ISDA agreement operates. It's consistent with this court's decision in Lehman Brothers. BDC didn't appeal from that case management order because it always contemplated a trial on the $125 million claim at the appropriate time, so there was nothing to appeal from. We weren't aggrieved by that issue. And as Justice Moulton pointed out, the $125 million claim was not ripe until 2020. We had the phase 1 trial. In phase 2, Justice Maisley held that BDC was the defaulting party, but she then checked the box, disposing of the whole case and the 57F claim without holding a trial on the factual issues surrounding Barclays' calculation. That error is at record site 667. We appealed to this court and won, and you sent the case back down for a trial on the $125 million issue. What Barclays is now arguing is that phase 1 was, for some reason, supposed to deal with phase 2 damages issues. The argument's nonsensical. It's also not how any of the parties proceeded in this case, which is why Mr. Scott didn't say anything when my former partner argued to the prior panel, quote, "We should be able to be heard on $125 million, and it's never been considered." That's at page 90 of the record, lines 1 to 8. I'll just point out as well that Barclays likes to cite Justice Branson's trial or order after the phase 1 trial, claiming, quote, BDC was not liable to Barclays. She was referring to Barclays not being liable in phase 1 on BDC's collateral call. It's clear from the face of that decision that's all that trial was addressing.
That was the October 6th collateral call, right?
That was the October 6, 2008 collateral call, absolutely correct. The record at 477, Justice Branson wrote in her post-trial decision, "The claims at issue in this trial revolves around collateral calls issued by BDC on October 6, 2008. Barclays repeatedly misquotes a sentence at the end of the opinion to argue that Justice Branson concluded that Barclays is not liable on any claim. What she held was that Barclays was not liable on BDC's collateral call. You just have to read the full sentence. This court affirmed that in their later decision, 176-83D at 455. Again, you're talking about the October 6, 2008 collateral call. That's all the whole first trial was about. It wasn't about Barclays' collateral call. It wasn't about our 57F claim. And Your Honors, just to be clear, under Barclays' formulation, the same trial is going to be held on its loss calculation, but their argument is even if Barclays was found to have unreasonably calculated $125 million and was over-collateralized by that amount of BDC's investors' collateral, they still get to keep $125 million of BDC's investors' money. That can't be right. They're asking the court for an unjustified windfall. They have no right to it. BDC's 57F claim has never been dismissed from this case. We've still never been heard on it. That's what we said in 2021.
125 was the escrow? Was the 124.9 million was the monies held in escrow?
It was collateral that was held by Barclays, so Barclays actually had $302 million. They claimed you owe us all that $302 million, and you also owe us $2.67 million more. That was their counterclaim. So they held on to that, and they engaged in self-help in terms of taking that collateral. So you've all been very patient. I just would ask for the trial to be held that Justice Branson contemplated and that this court previously ordered on the last appeal.
Thank you.
Thank you.
May it please the court, Jeff Scott on behalf of Barclays. Justice Branson never contemplated that she would have two trials based on BDC's breach of contract claim. That's not what happened.
In reading her her decision, I don't know how you come to that conclusion. Why else did she break it up into phases? I thought that was the reason why she had phases of the trial.
Right, so, and the phases are quite clear if you read her decision of April 7th, 2016. When we came back from the Court of Appeals in 2015, the parties disputed what needed to be tried. And what BDC argued, this is in the record, we want a full trial on the merits, and they also noted they also have an affirmative defenses to Barclays' counterclaim, and one of those affirmative defenses was they challenged our loss calculations. At no point when they argued to Justice Branson in 2015 and 2016 did they raise that they had an alternative breach of contract claim. What really happened here, if you look at their single breach of contract claim, They have 6 theories under it. One of those was that we breached in responding to their October 6, 2008 collateral call. They have another theory was dismissed by Justice Branson in summary judgment. Paragraph A is a claim that we did not act in a commercial way. They've never proceeded on that claim. The reason they didn't proceed on it was in considering what the scope of the trial would be in 2017, Justice Branson said there are 5 questions that the court needs to resolve, determine whether Barclays was liable or not. Those 5 questions were not favorable to Barclays. And we also know they had this alternative theory that we did the calculations incorrectly, but they made a strategic decision. That's a very hard claim to prevail on, because when we're the non-defaulting party, Barclays is the non-defaulting party. As the non-defaulting party, it gets deference to its loss calculations.
What would have happened at phase 2 if had you lost at phase 1?
Well, what she said in phase 1, she said, and this is at record 464, Justice Branson said at the April 7th, 2016 hearing, we're first going to try BDC's claims by deciding whether Barclays defaulted or breached. Then that would be followed by a trial on Barclays' counterclaims if necessary. So phase 1 was BDC's claim.
Yeah.
Phase 2 was Barclays' counterclaim. And then should Barclays win on that, the measure of damages? It was Barclays' measure of damages, not BDC's.
But one of the operative agreements here was an ISDA master agreement, correct?
That's correct.
And that contemplates possibly that loss could actually be a positive number in determining the parties' claims.
In this case, that would be countered. The loss was not positive. The loss was $305 million. We had $302 million of their collateral.
But at least it was a disputed issue. So wouldn't that have been heard at phase 2?
That would have been, that issue could have been tried in 2016. We would, if we knew they were going to proceed on this alternative.
No, that's not the question. The question is that was an issue that could have been tried in phase 2, depending upon what happened in phase 1.
It was an issue that should have been tried in phase 1. Phase 1 was BDC's single breach of contract claim. If they wanted to proceed on all their alternative theories of liability, including challenging our loss calculation where they could recover damages, they should have asserted that then. If they had asserted that claim then, we would have appealed to this court Justice Branson's 5 questions. But because they were moving on from that alternative theory, we said, fine, we won't appeal it. Remember, at the April 16th hearing, Justice Branson said, trying BDC's breach of contract claim
At the oral argument on the previous appeal here, there were arguments about this 129 mil.
No, there were not.
I thought that somebody said something about it.
Mr. Joseph said nothing in the summary judgment papers below in front of Justice Masley about an alternative affirmative breach of contract claim. He said nothing.
Then why did we remit?
You remitted because you found there was a factual issue between the competing experts' damages reports as to whether or not Barclays did the calculations in a commercially reasonable way. But without an affirmative breach of contract claim, this court—
There was no clawback. That's your argument.
They cannot recover damages. That
I'm reading the decision says we find that plaintiff's expert evidence raised an issue of fact as to the reasonableness and good faith of defendant's loss calculation.
That's right. So,
and we remand for a trial to determine whether the calculation was reasonable under the circumstances.
That's what the remitterer says, but the remitterer could not have remanded this for a breach of contract claim where they could find Barclays as liable, because Justice Branson found at the trial Barclays is not liable to BDC. They then filed a notice of appeal, and 3 times they said that was Justice Branson's holding without any limitation. It went back up to this court in 2019, and in October of 2019, this court held that Barclays is not liable on BDC's breach of contract claim. There was no limitation. They sought of appeal to the Court of Appeals. You denied it. So at that point in time, their affirmative breach of contract claim was over, and it's a basic tenet of the law. If they don't have an affirmative breach of contract claim, they cannot recover damages. Now, we agree with the multiple statements that BDC made for 6 years. They made it to Justice Branston, they made it to Justice Masley, and they made it to this court. Every time they mentioned this claim about our calculations, they called it an affirmative defense. An affirmative defense can go to limit our damages, but it cannot allow them to recover any damages because they do not have a claim at this point in time. And that's what Justice Masley found. If you look at the record closely here, they made a strategic decision. Here's why. Their claim in connection with their October 6th collateral call was worth $1 billion if you believe their damages. $300 million in return of collateral. They also got their rate of return for 7.5 years. That would have resulted in $1 billion claim. Their other claim, which was their other theory, may I just finish?
Yes.
I see my light. The other theory was Barclays didn't do their calculations correctly. But we get deference on that. And it's a very weak claim, so they clearly made a strategic decision not to assert that claim, so Barclays wouldn't appeal. When we won the trial, we told our investors in our SEC filings, our regulators, our auditors, we had no liability. We no longer had damages with respect to BDC's claim because its claim was over. Why would they, for 6.5 years, never mention to any court that they had this alternative breach of contract claim? They made a strategic decision to drop it, and this court now should not go contrary to the First Department's opinion in October 2019 when it found that Barclays wasn't liable to BDC on its breach of contract claim. Thank you, Your Honors.
Thank you.
Briefly, Your Honors, Barclays still can't point to any decision granting them judgment on the $125 million claim because there is none. Mr. Scott referenced the scope of trial arguments that were made before Justice Branston. Now, during the scope of that, Mr. Joseph did raise the issue that no matter what, we still have this issue of a $100 million claim if Barclays were to prevail on its counterclaims. They said that at the July 2015 hearing before Justice Branston, that's record 409. And in any event, Justice Branston denied both parties' motions.
Right,
and she
but
set up.
Judge Masley stated that when the case, based upon the decision by the Court of Appeals, Judge Branston then frames these issues, right? She frames 6 issues which were going to be discussed.
Yep.
None of them dealt with the breach of contract claim.
Justice Weber, all of them.
According to Judge Masley, right? None dealt with the breach of contract claim. And you never raised this as an issue. You never appealed her decision, her being Justice Branston's decision. So according to Judge Masley now, you waived that. So why is that incorrect?
No, because it's a mischaracterization, misrepresentation of Justice Branston's order. It didn't hold that after phase 2, we'll address Barclays' damages on counterclaims. What it says is, after that, of course, there'll be the measure of damages. And that is the parties' respective loss calculations, and that is the $125 million claim. That is what was brought up to Justice Branston in July of 2015. Justice Branston ruled, okay, we're going to decide who defaulted first, because that is the gating issue. Phase 1 trial is about BDC's collateral call. Those 5 sub-issues all had to do with BDC's collateral call. And that is why she says very clearly in her post-trial decision that the whole trial revolved around issues relating to BDC's collateral call. We never got to the alternative claim until 2020.
What I don't understand is, given the complexity of the case, given the number of times it's come here, gone to the Court of Appeals, et cetera, why wasn't it simply stated on the record or asked of Judge Branston, well, what about the breach of contract claim? When are we going to deal with that? When will that be addressed? Are we going to address that in phase 2? Are we going to address it in phase 3?
Your Honor, the alternative claim, which is the $125 million issue, all parties proceeded on the understanding that we would address that at the appropriate time.
No, it wasn't all parties because they totally disagree. They thought it was finished.
Respectfully, Your Honor, I think if they really were proceeding on that basis, then Mr. Scott at the last appeal would have stood up and said, wait a second, Your Honors, BDC doesn't have this $125 million claim. They never said it. Mr. Joseph couldn't have been clearer. If you look at our opening briefs at page 1920, we cite all the record sites in our earlier appeal that says Barclays shouldn't be entitled to anything. And in fact, BDC is owed $125 million plus interest. That is what we were arguing. That's what was remanded down. Again, we've never been heard on that issue, and we're entitled to our day in court on that issue. Thank you very much
so
for your
much.
time. I appreciate it.
Telefónica SA versus Milom International. You may proceed.
Thank you, Your Honor. Kimo Peluso, counsel for the defendants, appellants, the Milom parties. This is a case that involves liability issues depending on a condition precedent in a contract, and also an unprecedented ruling by the trial court awarding prejudgment interest.
Condition precedent, very important issue in this case, but doesn't the Liberty transaction, which happened subsequent, show the roadmap for getting this done, getting the deal done? And it didn't require comptroller approval, or it didn't require a controller authorización. I'm sorry about butchering that. Thank you. Yeah, I knew I'd get correctly so. In other words, if that's the case, if the Liberty transaction shows the way, the roadmap for getting this deal done, doesn't that show that comptroller authorización was not a condition precedent, because it would be commercially unreasonable because it wasn't a necessary step in the transaction?
Well, Your Honor, no, it would be not necessarily legally required under Costa Rica law, but whether the Liberty buyer was willing to accept the risk of finding out post-acquisition whether the controller will say yes.
But everybody's...
That's up to Liberty.
I thought you had plenty of heads up that it wasn't necessary, that you were hearing from other Costa Rican government actors that, no, you don't need this.
Yes, and when we heard that, Milom consistently said, that's fine, but we are not going to close until we get the controller to say, yes, we are approving this. It's not that they didn't need the controller's approval ever. It would, in fact, Telefónica's own expert conceded that if you did this transaction and you never got the controller's approval to change who the guarantor was in this public concession contract, that would be a violation of the bidding documents to that concession, which are still live obligations. It would put the acquirer in breach of the concession if you
but you'd get that approval post-closing.
You could, or you can have a contract that says, I will buy your company only if I already have the controller's approval in hand. Milom is not required to buy anything. It is perfectly within its rights to say, I am willing to purchase this company if certain circumstances are present. And if those circumstances are not present, and that's built into the contract, that is the quintessential failure of a condition precedent. We see this in all of the cases that are cited in our brief. In the Oppenheimer case, that was a situation where the landlord's consent was ultimately obtained. It just wasn't obtained in writing, and it was a little bit later than what the contract, days later than what the contract required. The Court of Appeal said none of that matters. Conditions precedent are not like contractual obligations of performance. With performance, we have sort of soft corners that allow parties to engage in substantial performance, substantial compliance with the terms. Conditions precedent are not treated that way. They are treated as strictly construed because they are the predicate in which parties are willing voluntarily to have a contractual obligation at all. In addition, nobody had known and could have known what the controller was going to think of this application at the time of the Milom transaction with Telefónica, certainly at the time of the agreement. Your Honor, this was a public cell phone industry until 2010. There were no private companies in this space. This was the first time any company had ever acquired a Costa Rican cell phone company in the history of the country, a country which is known for its curveballs in the regulatory world. The only question here is, what does the contract say? Does the contract say that Milom is required to close without the controller approval? And the answer is, of course it's not. There's a Schedule 6.1 that lists all the regulatory approvals. The authorization of the controller is spelled out expressly in that schedule. There's a condition precedent section, Section 6.1, that says in unmistakable language, these are the conditions precedent to the deal. And then there's a termination clause that says, if the deal doesn't close by May 1, because not all the conditions are satisfied, either party can terminate for any reason or for no reason. This is not a case where they are holding up a document saying, hey, we did kind of get the controller approval. They never did. They got a denial from the controller saying this is not the right procedure. You need to come back to us in a different form. And the controller never indicated to the parties that the application would ultimately be granted. The notion that Milom would have to then put up a $570 million, or by their math, $620 million purchase price to purchase a company under circumstances that were clearly spelled out as conditions precedent and obviously not satisfied beyond dispute, it could not have been required to engage.
So weren't those conditions qualified in the agreement as required to consummate the transactions?
That is part of the definition, Your Honor.
Or was it required to consummate the transaction? Was the approval required? Clearly, it was not as indicated by the subsequent transaction.
It was not legally required to close, but it was required in the sense that it is in the agreement. The controller approval is...
Yeah, but the agreement also says that required to consummate the transaction.
Yes, it does, Your Honor, but required to consummate the transaction. Elsewhere in the agreement, when the parties say required, they're very clear when they mean required by law. It doesn't say that. It says required. And you know, if my wife gives me a dinner party,
you're stopping at required, and I think it's unfair when it says required to consummate the transaction.
It doesn't say required by law, Your Honor, and I can just illustrate that whether something is required or not is very much the subject of the agreement. The controller approval is mentioned 3 times in this agreement as something that the parties had to get. It's in Schedule 3.4, it's in Schedule 4.4, it's in Schedule 6.1. The parties are free to say, we're deciding what's required, because remember, that definition is triggering the obligation to make reasonable efforts to obtain regulatory approvals, and they're free to decide what that obligation applies to.
All right, you'll have time on rebuttal.
Thank you.
You may proceed.
Thank you, Your Honor. Samir Edison for Telefonica. The overriding principle of contract interpretation in New York law is the courts must give effect to the parties' reasonable expectations. And as you just heard, Milcom's primary theory here is the parties inserted into this agreement an impossible to fulfill condition precedent, which gave each party a unilateral veto on the transaction at any time before closing, even when it's undisputed that all of the relevant regulators had said here, go ahead, they'd blessed the transaction, they'd said there's no regulatory risk. And I think that's the really important thing that's been missing here. You know, if you look at the record, you know, the Costa Rican regulators on February 4th said you should go ahead and complete the authorized action, carry out the transaction. That's at 522 of the record. Even by April 27th, again, they said
You're
they
not
reiterated.
suggesting that Milom should have rested on those assurances without government approvals in hand, are you?
They had all of the government approvals that were, every other regulator had signed off on this.
Every other. So they didn't have all of them. And the contract language was very clear. So why should your client not be held to the contract they entered? They had every opportunity to check and see whether this provision was even possible. So why should you not be held to the language you agreed to?
We think we should be, Your Honor. That's exactly why we put in place these dual protections. So we understood we were existing in a regulatory space that was uncertain. So instead of saying, you know, everything on this disclosure schedule, we have to get them, and if they don't exist, well, then I guess the transaction is blown up. Instead, we specifically said that it has to be required to consummate the transaction. The definition in the contract, the definitional section, says closing regulatory approval means the regulatory approvals, capital R, capital A, set forth in the section 6.1 of the disclosure schedule. So not everything in section 6.1 of the disclosure schedule, the regulatory approvals. What does regulatory approvals mean? You then look to the definitional section again. That reroutes you to section 5.4b, and that defines regulatory approval as any action, approval, authorization, clearance required to consummate the transactions. And they never...
You heard your opponent say that required is actually anchored to section 6.1, the schedule. And so you got to do it there. And there's no wiggle room because of those sections.
No, but it is. I mean, required to consummate the transaction, they never give effect to that definition. In the disclosure schedule, there it says closing regulatory approval in the title, but it also says, this is on page 260, descriptive headings have been inserted herein for convenience of reference only and informational purposes only and shall not have the effect of amending or changing the SPREX designation. So you've got to ignore the fact that that says closing regulatory approvals on the title. The title doesn't count. And then you look to what is actually defined as a closing regulatory approval. Section 1.1 says that it is the definition in 6.1a, not the definition on the disclosure schedule, in 6.1a. And 6.1a, as I just said, gives the two-part definition, two things. Not every item on the disclosure schedule, but the regulatory approvals set forth on the disclosure schedule. It has to both be a regulatory approval and set forth on the disclosure schedule. And that is the completely sensible thing for us to have done in this situation, which is we want to hear the things that we think, we're happy to say, we thought these were the things we needed. But if we don't need them, if they're not required to consummate the transaction, well, of course we're not going to blow up the whole transaction because the regulators have come to us and they've said, this is completely unnecessary. And if you look to the November 15th decision by the Costa Rican by the comptroller, it's denied as not required. And Ms. Seed always told us it's not necessary.
And that was repeatedly stated.
Repeatedly stated. We were told by everyone, not required down the line. And we told them, they said we assented to their idea this was required. Absolutely not. We never assented to it. If you look at 10873, 10854, there are emails, messages across the board that we always say, we believe that we can close right now. And in fact, the regulators were saying to them, it's very unusual. This goes to the question, Justice Moulton's question about the Liberty transaction. It's very unusual what you're asking for. Normally, what happens is you get the endorsement afterwards. That's what happened in Liberty. It was 9 months afterwards. And our expert said, of course, it's not a big deal. This is what you do every single time. It's, quote, a mere task for verification. Millicom's own counsel on November 18th said, as far as we can see, there is no sensitive issue that can put to risk of the operation. And
I want to talk about the prejudgment interest before we get too far down the rabbit hole.
Absolutely.
I mean, you're happy with the way it was calculated, I presume, but should it have been a smaller figure?
The way it was calculated, I think that, I'm not sure the other side really disputes this, is the only way that can actually make us whole. And, the Court of Appeals in Spodek, this court in IHG Holmes has always said, the key point about this statute is you have to calculate it in a way that makes us whole. So the way in which to do that here is you find out, so look at this statutory language.
No, but it says it's on a sum awarded, and that's how they hang their hat.
Correct, Your Honor. Interest shall be recovered upon a sum awarded because of a breach of performance of contract. So, and this is how Justice Bork explained it in the re-argument decision that we submitted, is that means you basically take the amount that we would have received but for the violation. So you look at the counterfactual world. What would have happened if Millicom hadn't breached? We'd have received $620 million. We would have put that into the bank. We could have earned interest on that.
Yeah, but you received a big chunk of change from Liberty, though.
Yeah. Exactly, and you do those offsets at the back end. So the way to make us whole is to say, in the counterfactual world, $620 million, put that in the bank, you get the interest from that. Then if we got some benefit from the fact that they breached, you subtract that at the end. But what you don't do is subtract that at the beginning. Their way of doing things double counts the mitigation, double counts the subtraction, because it subtracts it from the $620 million. You then get a lower amount of pre-judgment interest than we would have got. No one disputes this. Then in the counterfactual world, we'd have put $620 million in the bank. In their world, you're subtracting it at that moment, and you're getting a much less money on the pre-judgment interest, and then you're double counting by subtracting at the back end again the mitigation. They seem to say that we had value, we at least had this asset, but it's undisputed in the record. We got no value from this asset other than the $29 million dividend, and we also subtracted that. So that's the right way to do it. You do the offsets at the back end. And this is just a question of when you do the offsets. If you do the offsets at the front, you basically give too low an amount of pre-judgment interest that by any measure undercompensates as relative to the amount of money that we should have. And that's reflected in the case law, in the Trahan case, in SDNY, and in the Second Circuit's Wind River case. This is how they described it. The factual record before us is not sufficient to support a finding that the court awarded the full $48 million with a set-off for ACE's partial payment. But if you believe their theory, they should have just done that set-off at the beginning. But that's not right. You do this set-off at the end because there's no other way in which you can make a plaintiff whole. And under their model, here is what happens. If it were the case that if the Liberty sale happened on the last day before verdict and we got $620 million, under their logic, we would have zero damages. That cannot be right. We would have no prejudgment interest because you would have done this offset at the beginning, that would have zeroed it out. And then even though, you know, they got a huge amount out of their breach. They breached the contract. They kept $620 million. They used that during COVID-19. We didn't want this asset. We were harmed by the fact that we had to hang on to it, and then we sold it later on at a massively diminished price. Under their model, if we had just sold it for the same amount, we would get zero damages. Prejudgment interest would be zero. I think under any measure, that doesn't make us whole. And I'm not even sure they really dispute that. They just say—
On the day of the breach, you had all the shares still.
Yeah, and it's undisputed in the record, and our expert said this, that we didn't get any value from that other than the $29 million. So we held on to the asset, sure, but we didn't want the asset. That's the whole point. The counterfactual world is we wanted—
valueless asset, that's the point.
Yeah, you value the asset, but you do that as an offset at the end. You do that as the offset at the end. We're not saying you don't count that. The question here is, when do you count that? And if you use their approach, we end up getting zero damages if we end up getting the same purchase price at the end. But that can't be right because we would have lost use of that asset for all of that time. And the whole point of prejudgment interest is to compensate us for the lost use. And I think basically their argument is, you know, I'm not sure they even dispute that. What they basically say is you labeled this wrong. You should have called this something else. We asked the court below for incidental damages. We said you can call it prejudgment interest or incidental damages. And lots of cases describe the difference between those two things as being academic. So they're sort of saying you should have called it something else. Either way, we think we're right to call it prejudgment interest. If you disagree with that, I think at least Justice Brook has to take a look at this and allow us to have this as incidental damages. We did ask for that below as well.
Thank you.
Thank you, Your Honor.
Three things. Everything my friend just said he thinks we don't dispute, we dispute. If they were harmed, they can prove damages. If they were harmed in some way, they can prove consequential damages, they can put in evidence, and the court can decide whether it's proven and can award damages. They didn't do that. We begged them to do it in discovery. Tell us what your damages are from the delay. They had nothing. There is no statute that gives you damages because of a delay of payment. There is a statute that gives you interest on a sum awarded, which is an amount in a judgment. And the reason we know that is because the CPLR says the clerk is the one who calculates prejudgment interest based on the judgment. And the damages here, the sum awarded, never could have been the full $628 million purchase price because damages owed to a seller when a buyer fails to close on a transaction is the contract price minus the value of the asset. Imagine the asset was another form of currency, and imagine this same argument, someone complaining, I had this asset, I couldn't do anything with it, but it was cash. It would be the same thing. It doesn't matter whether you can do something with it. What matters is the value of the asset. Everything regarding the interpretation of the agreement that's proffered by Telefonica today is a litigation position that they did not take for months. I would encourage the panel to look closely at the language in the agreement and our briefs, but understand this. In March or April of 2020, they came up with all of these arguments for the first time. Everything they had been saying for months before that was consistent with Millicom's position in this case. They are now trying to say that the November 2019 comptroller decision was some watershed moment that left everybody realizing that there was no more condition precedent. That is simply counterfactual to what actually happened. What actually happened was Telefonica complained internally, complained to Millicom that this is going to delay our closing. We cannot close now until much later than we thought because we have to get the comptroller approval. And if I may, the best—
You have 30 seconds.
Thank you, Your Honor. The best illustration of this is that the Global General Counsel of Telefonica in January of 2020, 2 months after that decision, was writing to the ambassador from Spain to Costa Rica to enlist no less—
Is this in the record?
Yes, Your Honor, it is. They enlisted no less than the Kingdom of Spain to try to expedite the process, and in that email complained the comptroller approval process is slowing down our closing. We can't close until we get that approval. That is not a party who thinks the condition precedent was excused.
Thank you. Brook versus Muser.
Good afternoon, Your
Good
Honors.
afternoon. You have 3 minutes.
Thank you. My name is Dan Isaacs. I represent the estate of Judith Brook in this appeal, which stems from the Supreme Court's granting of nearly $400,000 in attorney's fees in a contested surrogate court proceeding from which my client, Judith Brook, received no benefit. It was the 5th largest award of fees in a surrogate court proceeding in this county in 5 years. I should also note at the outset that at no time have the underlying proceedings ever had appellate review. This court has issued 2 decisions, as Your Honors are aware, regarding this matter. The first was in March of 2021, when the court dismissed as moot the appeal, the January 3rd order that had made Mr. Rotolo the guardian of my client, because it was moot because my client had died. There was a second subsequent appeal taken for the denial of discovery during the fee proceedings. And in that decision, this court had stated that the merits of the underlying application had already been decided in the other appeal. But there was no analysis of what went on in the guardianship court. And quite frankly, what went on was a complete deprivation of my client's constitutional rights to be present for the hearing, set forth in the record. My client wanted...
Counsel, you want us to revisit the finding of incapacitation, right?
Fair enough, Your Honor.
The ship has sailed.
Well, it's...
You want to talk about, I mean, again, this, I don't want to speak for the whole panel, but why don't you talk about the fees?
Well, when you look at the fees, Your Honor, again, what benefit did my client receive? She received none. Mr. Rotolo, for example...
Well, she received care.
Well, Your Honor...
She received care that the court found was lacking. And to the extent that there was extensive litigation, that in part was due to the constant proceedings and objections and lawsuits filed in federal court and accusations against judges, et cetera. So to the extent it was run up, doesn't fall on the people who had to do the work.
Well, Your Honor, it's respectfully suggested that no fees should have been earned from the time that my client died on March 15th. She received...
Because everything just stops, right?
What happened, Your Honor?
Doesn't the court have to have procedures to wind up on a guardianship? And so should the people who have to do that work, who have been appointed by the court, not be paid?
My clients...
I've asked the question. Should they
Yes.
not be paid after having been appointed by the court to do a job?
Yes, Your Honor, but not for acts of malfeasance and misfeasance, which is what happened in this case. For example, Mr. Rotolo tried...
All right, I'm going to give you 30 seconds.
30 seconds. Set forth in our papers, Mr. Rotolo sold millions of dollars worth of my client's stock on the date she died in order to gin up his commissions. And the Supreme Court actually reduced his attorney's fees because of the actions he took, which cost the estate hundreds of thousands of dollars in taxes and attorney's fees. With respect to the other attorney's filings, fee on fee, they were charging my client's estate for research. You don't charge a client for research. You should, well, if you take a case, you know what you're doing.
Thank you.
Thank you, Your Honor.
Respectfully, Your Honor, the ship has not sailed. The case of Brook versus Crosson, 85 New York.
See, we speak, you have to allow us to speak, and then...
Yes, Your Honor.
You're speaking, the estate has spoken, but you were on the other appeal, so that ship has, well, go ahead, tell us what you want to tell us, Doctor.
Right. So the 2021 appeal was declared moot. The merits of the 2021 appeal was not decided. The 2022 appeal, the court made clear error, citing only the 2021 appeal as the basis that the merits of the guardianship court decision had been subject to appellate review. But there never was any appellate review of the facts and law of the guardianship court decision. It is a constitutional right under the case law cited that everyone has a right to appellate review of the facts and law of any proceeding. And my mother had a right to be present at the January 3, 2020 hearing. She said she absolutely wanted the hearing postponed so that she could be present. That right was denied. We received the court evaluator report on January 2nd at 4:14 p.m. It had vague new allegations, We had no time to prepare. My attorney on January 3rd asked for an adjournment of a few weeks. It was denied. We were egregiously denied due process in that proceeding. Now, in Brook versus Crossan, 85 New York 2nd, 10, the Court of Appeals of the State of New York decided, so in that case, there was the upstate judges were suing because they weren't being paid as much as the downstate judges. They won that. The state did not appeal. The upstate judges then moved for attorney's fees, and the state then contested that and lost in the lower court, and then they appealed up to the Court of Appeals, and the Court of Appeals decided that that because there was no final judgment on the merits, that when there's a fee proceeding, all of the facts need to be reviewed. In addition,
Thank you. We're out of time. Next, 5 minutes.
Good afternoon, judges. I'm Lisette Ferreira, and I represent the guardian, Joe Rutolo, and I will take 3 of the 5 minutes for joint respondents. Your honors are in the best position to assess what this court did and did not decide in the prior appeals. That ship has sailed. The sole issue on this appeal is whether the court presiding over the guardianship providently exercised her discretion in awarding the sum of approximately $56,000 to my client as guardian and the other professional sums that were awarded.
What was the total of the estate?
I'm sorry, Judge?
What was the total amount of the estate?
I believe the estate had approximately $8 million.
8.2 million. And how much was given out in attorney's fees?
I believe that in all of the attorney's fees and other professional fees, including fees to Dr. Brook.
Well, I was going to ask that as well.
Yeah, was approximately $400,000.
So $400,000 to the attorneys and to the guardians, right? And then how much was actually given to the doctor for payment of his litigation?
I believe that the amount that was given to him, let me just find that. Let's see.
Whatever the amount was, there's no one's contesting, or at least the doctor's not contesting the monies that were given to him. Is that correct?
Well, yes, he's not contesting those fees. The statement that there were this $400,000 in fees that were awarded is the highest ever awarded. There's a citation to a website there. If you go to that website, that's not what it says.
Yeah, we don't go to websites. But counsel, my other question is in terms of their statement that the deceased was not allowed to appear at the proceedings. Is that correct? And if so, why was she not allowed to appear at the proceeding?
There were multiple proceedings at which the decedent did appear. There was one proceeding on January 3rd, 2020, at which she did not appear because she had just been discharged from the hospital. However, her attorney, Diana Rosenthal of Mental Hygiene Legal Service, did appear on her behalf and waived her appearance as is permitted.
Well, that was my other question. In all of these proceedings, she was represented by counsel, is that correct?
She was represented by counsel, and Mr. Isaacs is not the attorney for Judith Brook. He is the attorney for the estate of Judith Brook, of which Dr. Adam Brook is the sole executor right now.
Right. And you stated that she did not appear in January 2020?
January 3rd of 2020, it's my understanding.
And she passed in March of 2020.
She passed in March
2 months
15th
later.
of 2020, yes.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Ira Salzman. I was the court evaluator in this case. I'm appearing per se. I have 2 fast points I would like to make. First, Adam Brook argues in his reply brief that Mental Hygiene Law 8144, pursuant to Mental Hygiene Law 8144, only the surrogates court can deal with fees on guardianship proceedings after the death of the alleged incapacitated person. This was first raised in the reply brief. Uh,
But that's not correct, is it? That's
no,
not correct.
That is not correct.
As I sat in surrogate's court and was acting surrogate in here in New York County, I'm fully aware of the fact that that is not
So
correct.
this court has held in Caminesta versus Foldis, 51 AD 3rd 528, that the Supreme Court has concurrent jurisdiction with the surrogate's court with regard to estate matters pursuant to Article 6, Section 7 of
Well,
the
he also states that it is unconstitutional, or is, that it doesn't apply to him, the MHL 8110, right? Isn't that one of his arguments as well?
With regard to which issue, Your Honor?
I thought in the papers the argument was made that based upon her condition or based upon her status, that MHL 8110 didn't apply to her.
I'm not aware of that argument, Your Honor. The second issue is the constitutionality of the award of fees in this case is not properly before the court because, as has already been noted, the authority to retain the court has previously held that the trial court had the authority to retain.
And there was a hearing that was conducted and with documentation that was submitted, and the court made a determination as to the fees that would be awarded.
That is correct, with witnesses, multiple days.
And she actually deducted some of the fees based on what she heard,
Yes,
correct?
she did, including mine.
I know.
Yes.
Basic, and in any case, guardianship statutes are clearly constitutional under the parents' patriae power. There are a lot of recommendations that appear in Dr. Brook's report. Just because you could make it better doesn't mean it's unconstitutional as presently drafted. Thank you, Your Honors, very much.
Thank you. Okay. You have 1 minute.
Thank you, Your Honor. Very quick, just wanted to bring 2 points to the court's attention in context of this underlying proceeding. First, on January 2nd, the day before that January 3rd hearing, where Dr. Brook had wanted to be, there was a conversation between Mr. Saltzman and Mr. Rotolo, following which Mr. Rotolo billed my client's estate 1.3 hours to prepare an order for a hearing that had not yet even been held. And at the conclusion of that hearing, handed it up to the judge, and she signed it after Mr. Saltzman said what a Superman Mr. Rotolo had been. The second point is that Dr. Brooks, Judith Brooks' daughter-in-law, who's an accomplished attorney, had also cross-petitioned to be awarded guardianship.
And after a while,
denied.
because it was a co-guardianship, I thought, and she did not wish to be co-guardian. And that's why she then withdrew her application or request.
But she would have been the
But she did not wish to be co-guardian. She wanted to be the sole guardian. I have a question to you, and you represent the estate. Who comprises the estate?
Well, Dr. Brook is the executor, but there's 3 beneficiaries. It's himself and then his 2 nieces who
So
are
in your representation of the estate, are you also having issues with his monies that were expended to him for his litigation? Are you also claiming that those monies should be brought back into the estate because he did not have a right to those monies?
Well, I think the argument would be, Your Honor, is that he had to spend those monies to litigate on behalf.
Right, but you are representing the estate. So
Correct.
as your representation of the estate, you wish to have as much monies brought back into the estate.
Yes.
So are you also challenging the expenditure of monies to him?
I have not, Your Honor.
Why not?
It's not been challenged, but
Do his nieces say it's okay that he spent all that money on litigation and they're all right with, I'm sorry, you don't have a right to speak now.
Yes, Your Honor.
So did you speak with the other beneficiaries to see if they were okay with you not including the legal fees that were expended for the doctor?
No, Your Honor, I have not.
So do you think perhaps there's a conflict there? Again, I'm just wondering, in surrogate's court we dealt with this. I'm just wondering, is there not a conflict there? Are you representing all of the beneficiaries under the estate, or are you just representing one individual?
I'm representing the estate, Your Honor.
And so in your representation of the estate, you don't think that there's an issue as to all monies that were expended, not only to the attorneys and to the guardians, but also to the doctor here?
Well, we're requesting that the fees be expunged or reduced based upon wrongdoing.
And what about the funds that were expended to the doctor? You're also requesting that they be expunged or vacated, or that he return those monies?
If the court would sua sponte, grant that, put it back.
Are you accepting his coaxing here that he's signaling to you, yes, answer yes?
No, I'm not. I'm looking at.
Okay.
I'm looking at the bench.
Yeah, but you can't help but see the man shaking his head.
Agreed,
Yes.
but if he
Yeah.
shakes his head up or down, it makes
Thank
no
you.
difference.
Well, I have no further questions. I don't know about anyone else.
So if the court could expunge it to bring all the fees back into the estate, that would be wonderful.
Thank you. You have 2 minutes.
Thank you, Your Honor.
So, my mother's court-appointed attorney waived my mother's appearance without ever discussing it with my mother, and despite the fact that she heard a recording of my mother saying she wanted the hearing postponed so that she could be present. Number two, promptly upon being appointed guardian, Joe Rotolo dumped my mother in a nursing home against her will, forced her to stay here, forced her to stay there, directed nursing home staff not to discuss her medical condition or care with me. They didn't give her any of her medications, including pantoprazole, which prevents GI bleeding. My mother developed a GI bleed. They didn't take her to a hospital. They did CPR. She causing a rib fracture. She got pneumonia and died 71 days after the power of attorney was voided. The facts and law of the guardianship proceeding have never been subject to appellate review, and they ought to be. Mr. Rotolo lied repeatedly during the January 3, 2020 hearing. He said I had not paid payments for home care services when in fact I paid $235,516 for home care services over a 7-month period. Do you have any questions, Your Honor?
No, thank you. Port Morris versus Sangara LLC.
Good afternoon, Your Honors. Vladimir Mironenko for the defendants' appellants in this case. In the first instance, we respectfully request that this court reverse the order of Judge Tuitt, which denied our motion for a money judgment after first ordering that the tenant pay use and occupancy in this case, which the tenant then did not pay without any justification. This court will recall what we refer to in our brief as PMD1, a case between the same parties that this court decided earlier this year on virtually the exact same facts by a different justice in the same court. In that same case, as is here, the court ordered the tenant to pay use and occupancy, as is routinely done when a Yellowstone injunction is granted, as was the case here. The tenant refused to pay. The tenant in this case attempted to distinguish this case from that case by saying, well, here the tenant was constructively evicted. First of all, an argument that they never raised down below. Second of all, completely irrelevant because as this court held, and they actually raised the exact same arguments in PMD1, which they say they didn't, the obligation to pay the rent is an independent covenant. And they have their remedy. They can pursue the case, they can pursue their damages claim, something that they completely failed to do. They have not moved their case an inch since they filed their case in 2018, which means that this entire case was brought solely for them to obtain the Yellowstone injunction so they can stop our client from enforcing our client's rights, which effectively happened for the course of many, many, many years. The second part of our request is to direct the payment of the bond, which the court ordered and is also routinely granted as part of the Yellowstone injunction. Now, the court, sua sponte, essentially
vacated the bond
and said that in what we call sort of reverse engineering, that we had to make an actual motion in order for the bond not to be vacated. Now, we did make the motion.
Well, your application was timely because it fell on a Saturday, and so you did it on a Monday.
It was on the last day, but we respectfully submit that it was timely because it fell on a Saturday. And therefore, we believe that a money judgment should be issued in the amount of $134,047 which was
Just to return to your first point, I mean, if there are facts tending to show, I know you don't agree, but a constructive eviction, doesn't that mean that there has to be a trial about that before you get your UNO?
I think there's two completely separate issues. The issue with respect to constructive eviction, if there is one, which, by the way, there wouldn't be a trial on because it's not part of their pleadings. They never raised that issue. That is not a defense to the payment of use and occupancy. Otherwise, any tenant can always raise the issue to say, the landlord did something wrong. It doesn't matter that the court ordered me to pay use and occupancy. I can just ignore it because I'm saying that they never moved to vacate the order directing them to pay use and occupancy. In fact, in the very decision that we are appealing from, the court continued and ordered them to continue to pay use and occupancy. So the only thing the court said is there's a question of fact as to the parties' allegations as to what happened here. That is not enough for them to be excused from paying use and occupancy, as this department has held for decades and decades and decades, starting with the Calvert case and ending with the PMD1 case, which dealt with the exact same issues, where they also argued that there was some wrongdoing by the landlord, which, by the way, we completely dispute, and the affidavit of Samuel Chuang and the affidavits annexed to the papers on the motions below demonstrate that their allegations of any wrongdoing by the landlord are completely false.
Okay.
Thank you, Joe.
You may proceed.
May it please the court, Christopher Ryan Clark on behalf of the respondent. Your Honors, this case differs significantly from PMD1, and here's the reason why. In this particular case, the conduct attributable to the landlord specifically frustrated the purpose of this leasehold, resulting in the construction eviction of my client.
Tell us how.
How is that? Well, Your Honor, as the court will see when it looks at the initial Yellowstone injunction that was issued in this case, the court specifically directed the landlord to do whatever was needed to facilitate Port Morris, the tenant, from being able to complete their application for a certificate of occupancy. Now, the court, in the record before the court, was shown demonstrable evidence that there were a number of occasions in which the landlord did not cooperate with the tenant to do what was necessary in order to obtain that certificate of occupancy.
Yeah, can you raise this, I mean, you raised those facts perhaps below, but did you raise the actual legal argument of constructive eviction below?
We hadn't vacated the premises yet, Justice Moulton, so that's why the constructive eviction was complete post-briefing. But what's essential for the court's analysis, though, is the conduct. And we start with the beginning order that the court issued in sort of flavoring what the analysis should look like. Again, the court says specifically you have to cooperate with the tenant to allow them to do these things.
There was some repairs that needed to be done to the roof.
There were some roof repairs, but most importantly, Judge Manzanet, was that you had to have the Alt-1 application withdrawn by the landlords so that the Department of Buildings could go ahead and process the tenant's application. The court below had both a letter from the Bronx Borough Commissioner as well as a letter from my client's architect that highlighted the fact that essentially our performance, our ability to cure, the notice to cure, was rendered impossible.
Right, so your architect sends a letter January 10, 2022, where he or she talks about the fact that they are tasked to close out the open permits, but they can't do so because that the Alt-1 applications on the building is still pending.
That's correct, Justice Weber. That specifically would prevent us as the tenant from being able to proceed through the Department of Buildings process in order to get
there's a final plumbing sign-off that was needed in order to move forward?
Correct, and obviously that was out of our control, Justice Weber. That was only something that the landlord and the landlord's architect and design and construction team could do. We're the tenants. We don't have the ability to supersede them or take over that application. It was their application that they had to close out, and then we could go ahead and do our Alt-2 to be able to move forward and get our certificate of occupancy for the premises. Now, that's one of the essential reasons why this case is different than PMD1. In PMD1, there wasn't the kind of conduct that essentially made it impossible for us to use the storage space that was leased under that particular lease that was at issue and before the court. Here, the entire purpose of this lease was to operate a restaurant. We got the Yellowstone injunction in order for us to work cooperatively with the landlord to design what we needed to design and get the appropriate sign-offs from the Department of Buildings so we could go ahead and we could legalize our restaurant. Now, when the Yellowstone injunction was first issued, we continued to pay rent all throughout COVID for many years, and it only was when it became clear that the landlord was not going to cooperate with us and help us obtain that certificate of occupancy and legalize our restaurant that we ultimately had to shut our business, and it resulted in us having to vacate the space and surrender the space to the landlord. Now,
Counsel, I'm sorry to interrupt you.
Yes, Justice
Can you
Rosado.
respond to your friend's arguments on the vacating of the bond?
Well, in terms of the vacator of the bond has been vacated. I mean, the surety has returned everything at this point. It's sort of a moot point at this point. There was no stay, sought by the appellant when they filed this appeal to try to stay the surety from vacating it. It's gone at this point.
Right,
There's
but
nothing
if
to draw
if
down.
the vacator was improper, then what's the remedy? Should there not be some remedy?
The remedy, well, I mean, if the remedy would be to have a money judgment. I mean, the bond issue is gone at this point. I mean, obviously, we're not going to reinstate the bond since the leasehold has now been surrendered and there's no continuing injunction. So I don't believe that being able to draw down on the bond at this point would be something that would be available since it's already been released by the surety company.
But it could be reinstated, right?
It could be reinstated, Your Honor, but I don't know how you would fashion that in an order in terms of directing a tenant who's no longer even there to basically establish the bond with the surety. I don't think at this point, absent an injunction, that would be something you could bring back. Certainly, you could reverse and say that the court below erred, but in terms of actually directing.
But if the court erred, then what's the solution? Does it get remanded back for some determination of what should have been allowed?
I think that the determination that has to happen is the determination of the facts and is whether or not the landlord breached the specific order that the lower court issued saying that they had to cooperate. They breached that order in the first instance, and by doing so, constructively evicted my client. In terms of
the bond could be reinstated pending that determination, right?
I understand, Justice Weber, where you're going for, but again, considering they didn't, try to stay the surety and it's vacated, I think that.
But the tenant is out, and the tenant does not intend to return to the premises, right?
Can't do anything, Justice Weber, because the whole point of taking this leasehold was to operate the restaurant, and because the landlord wouldn't cooperate, despite the fact that they were directed to do so by the trial court in multiple orders.
So that ship has sailed.
In terms
was said earlier.
In terms of developing the premises, no, we're gone. I mean,
Right, so that ship has sailed. That's not an option anymore.
Yeah, the Yellowstone I mean, possession has been surrendered at this point. It's really about, can the landlord get a money judgment for the rent? And what I'm saying is that you have to read this in the context of all the constructive eviction case law that the court has. It's not something as simple as a Yellowstone, you can get money to extend the leasehold and preserve the status quo. That doesn't undermine all of this court's precedents that says that if the landlord engages in conduct that substantially frustrates the purpose of the lease and ultimately results in the constructive eviction, that is a bar to obtaining a rent judgment.
Got it. Thank you. You have 2 minutes.
Thank you. The case law the council is referring to is not a defense to paying court-ordered use and occupancy. And I would just like to note that
Why should we not find that your clients indeed constructively evicted them in light of not cooperating with the very purpose of the injunction was to have you cooperate with the obtaining of the certificate of occupancy?
Thank you, Judge. So those allegations are actually completely not true. First of all, the purpose of this lease was not to operate a restaurant. It was to operate a distillery. They were operating a distillery in the premises. They are the ones.
They want to expand their operations to include food?
They did want to expand
Okay,
operations.
so that's
to
not
include
completely
food.
false then.
That came after the fact. That was after the lease was entered into. At the time the lease was entered into, the lease was solely for the purposes of a distillery. They took out an Alt 1 on the building for the purposes of obtaining a certificate of occupancy to convert the building to allow them to use the premises as a distillery. It was their Alt 1. The reason that a stop work order was issued was because their architect withdrew from their Alt 1. Later, in the context of the PMD1 case, we met at the premises together
Watch
with
your
Justice...
finger. You're getting mighty close. Okay.
Together with Justice Franco, we met at the premises, and the parties entered into an stipulation, which Judge Franco so ordered, in which they took upon themselves the obligation to reinstate the Alt 1, to include the restaurant in the context of the Alt 1. All of this is in the record, and all of this was their obligation. They then did absolutely nothing in furtherance of the Alt 1. They did nothing to have the stop work order issued. There was nothing that the landlord did to interfere with their work.
There were allegations that there was a lack of access. Is that true?
They're alleging lack of access to a roof for the purposes of one inspection. What happened in that particular instance was they came with a ladder without providing any insurance, without providing information of who's coming to get access, came with a ladder, put a ladder on the building in a completely unsafe manner and started climbing onto the roof. And if I may just briefly with respect to the
You've
issue
got
of
30
constructive
seconds.
eviction-
I've had people waiting here for 3 hours, so.
Thank you very much, Judge. I believe counsel just doomed their very own argument by admitting that they did not vacate the premises until August 2023. It is an required element of constructive eviction for the claimant of construction eviction to abandon the premises. They admit that they did not vacate the premises until August 2023. That is precisely the date through which we are asking them to pay use and occupancy, and that's exactly how our calculation is done. And on the issue of the...
No.
Thank you very much for your time.
Give an inch, they want to take a mile. Okay. Bank of New York versus Del Rio. You may proceed.
Good afternoon, Your Honors. My name is Jordan Smith, representing the plaintiff appellant here at Bank of New York Mellon. The Supreme Court in the Bronx County erred in finding the foreclosure complaint time-barred. It ignored in its decision our principal arguments there and our principal arguments here, which are that the defendants here, the Del Rios, are judicially estopped from challenging the foreclosure due to their surrender of the property in the bankruptcy, as a benefit of which they received discharge of this debt and there are many other debts.
They checked that box.
Yes.
On the bankruptcy form, but that's not self-executing, though. That's just saying this is, I think the title of that page is debtor's statement of intention.
Correct.
So something has to happen after that, no?
Correct, but it is enforceable.
Which might include your client doing something affirmative, like, bringing the foreclosure action.
Correct, and when, we brought a foreclosure action later, after that.
So why wouldn't they be entitled to pursue any defenses they may have in a foreclosure action?
Because they surrendered the property and it's a judicial estoppel. They received the benefit
No, they
of
said they
bankruptcy.
intended to surrender.
Yeah, there was no surrender. There was no document saying we're surrendering the
Correct, but the mechanism of that is that they can't contest the foreclosure, and there's a lot of case law on that around the country that we've cited.
Around the country, is there anything here in this department which talks about that?
No, Your Honor, there's not in this
I didn't
department.
think so,
It's
because
a
I think
new
this is
issue.
the second case now that I've sat on where the same arguments have been made. So there's no case law here. Is that correct?
There's not a case law on the first department. Correct. I mean,
Is there anything in the second, third, or fourth department?
there's at the trial court level. There is.
Anything in the second or third or fourth appellate division?
No, but nor is there any contrary authority, Your Honor. So it's
There's no authority, period. So if there's no authority, period, then it's not going to be contrary, or nor is going to be.
Well, there's a lot of persuasive authority. It's an issue that the court needs to decide, and I think it's
Yes, so why don't we talk about that? And how does the fact pattern here play with the FAPA?
Well, I don't think we should reach FAPA. No.
No, we're gonna read FAPA. So tell me how FAPA interplays with the facts in this case.
Well, I'm aware of the court's decision earlier today in the Dalal case, I don't think this case is distinguishable from that, so I'm not going to pretend that I'm going to talk you out of it. I don't think that obviously we disagree with that decision, but I'm aware of 4 of the 5 justices up here were on that decision.
Right.
You probably haven't changed your mind in the last 5
We're not likely to
hours.
reverse ourselves in less than a month. So tell me, what about what we decided you think is, that you'd like to take issue with and would like us to consider?
Well, can I make my other argument, which is non-FAPA related, Your Honor? Which is,
You can, but we are going to absolutely consider FAPA. So if you want us to consider your argument without you addressing it, we can do that too.
okay, well, I think I'm usually told in these things to address my strongest arguments. My strongest argument
right
here is
ahead.
that FAPA doesn't apply, Your Honor. In this case, the complaint that supposedly accelerated the debt didn't even refer to the Del Rios or the right debt. It was filed in the wrong county. It referred to a property in White Plains. And the Del Rios came in response to the first case and said,
So
this
let's take the October complaint, then, which is your argument, as the operative complaint. Then isn't it still the case that the stipulation, the 2015 stipulation, has to somehow deaccelerate?
If the loan was never accelerated because it wasn't done properly.
It was on
It was
October
on
23rd.
On
October,
it was.
That was a nullity because there was no permission to file that. And that was just.
I mean, you're relying on your own mistake?
Well, correct. I mean, that's in our papers.
So you make a mistake, and so therefore you're able to benefit from your mistake?
You can in certain circumstances. I mean,
in what circumstances? When we're talking, I'm sorry, in what circumstances in the context of mortgage foreclosures are you able to benefit from your own mistake?
Well, if you file a complaint and it doesn't refer to the right people or the right loan and it's filed in the wrong county.
And then you
not
file the right
acceleration.
complaint, naming the right people, the right property in the right county, and you accelerate the loan, why doesn't the clock start ticking on that date?
Because that was a nullity, Your Honor. They
You
weren't
get
allowed
to
do that.
declare your own nullity?
No,
I thought the court
law
gets to
says it's a
declare that.
nullity. The law says.
So what court declared the October 23rd, 09 filing a nullity?
Well, there's no order that says that is a nullity,
There's
but the
no
law
order.
says it's a
So-
nullity if you file something that isn't, you're not allowed to file.
So you acknowledge that you did something contrary to the law, and therefore you're stating that you should benefit from your own error in disregarding the law.
Well, again, the Del Rios were themselves contesting that it was done right in that case. They said, this isn't done right. You haven't accelerated our loan. I mean,
And you're
that's
saying,
their
no,
argument.
no, we did it wrong. We did it wrong. That's your defense. We did it wrong.
Well,
All right, you'll have time on rebuttal.
Thank you, Your Honor.
Really? Does he have to?
You may proceed.
May it please the court, Mark Rube for the New York State Office of the Attorney General.
We going to talk about FAPA?
You can talk about FAPA.
Thank you.
This court's decision in Bayview Loan Servicing versus Dalal is largely dispositive of appellant's constitutional challenge here. I think the one distinction perhaps is that this case raises a takings clause claim, which wasn't present in Bayview, but I think the court's reasoning in Bayview that there's no contract or property right is dispositive of the takings clause challenge as well, because a property right is a threshold element to state a takings clause claim. I'm happy to answer any questions the court has. I know that 4 of the 5 justices were on the Bayview panel and are very familiar with the issues here, so I don't want to overstay my welcome, but I am happy to be helpful to the court however I can.
Thank you. I don't see anybody chomping at the bit, so thank you. Okay, you have 1 minute.
Thank you, Your Honor. With regard to the takings clause challenge, the decision in Dalal does mention takings clause, but then doesn't talk about it. So I don't know if it was hiding in the paper somewhere, but wasn't specifically addressed. I think clearly it was a regulatory taking, and that's a strong argument for why FAPA is unconstitutional as applied in many cases, including this one. On the day that, on December 29th, 2022, we had a valid mortgage and a timely cause of action. At the stroke of a pen, it goes away. And the mortgage has no economic value. It's a classic regulatory taking. And
Is
so
that what it says, though, that you no longer have a valid mortgage?
it's the effect, Your Honor. It's an as-applied challenge. You know, we're not coming in here and saying you must strike FAPA from the books. It can never be constitutional. In fact, you know, I think every part of it is constitutional going forward.
So your reading of it is that you therefore no longer have, after it's signed, that stroke of the pen or whatever, you no longer have an ability to bring any foreclosure actions?
In that, as applied to this mortgage and to some other mortgages, absolutely that's the case. Because, you know, the law was what it was when we filed this action in 2019. And I don't think anybody would contend that this action was untimely in 2022. It's only that legislative action that causes the mortgage to go from being a valuable piece of property to absolutely nothing. And that is a regulatory taking. And it has to meet those standards. And so again, this is an as-applied challenge.
Thank you so
Thank you.
much. People versus Justin Holmes Austin. You may proceed.
Thank you, Your Honors. Good afternoon. Ronald Zapata with the Office of the Appellate Defender for Justin Holmes Austin. The firearm sales count of the indictment was jurisdictionally defective because its factual allegations of sales taking place in more than a year were in contradiction to the one-year element of the statute. The analysis is very straightforward. The first-degree sales count requires the requisite sales take place within 1 year, but the factual allegations...
Counsel, looking at we've read the indictment, and I'm sure you have too. You look at the overt acts, and it sets forth the dates of the sale, and if you look at it, it's all within 1 year.
Yeah, but Your Honor, what counts for this count is the factual allegations in that count. The factual allegations in that count do not allege what counts.
But aren't the overt acts? I'm sorry. Aren't the overt acts also incorporated by reference into each of the counts?
No, they're not. They're only incorporated in terms of the conspiracy. So the overt acts only refer to the conspiracy. So the firearm sales count only alleges this one
The overt
line.
acts, they specify when the sales are alleged to have happened.
Well, here's the problem. We don't know which of those sales refer to the firearm sales count. But again, the
But
way...
if they're all within 1 year, why doesn't that satisfy the requirement?
One, because we don't know which of those sales are supposed to be part of the count. But the issue here...
Counsel, I'm not understanding that because I read the indictment, and the way that the overt acts are listed, it's listed by, on so-and-so date, your defendant sold to an undercover police officer. Clear as day, that is a sale of a firearm and the date. You take the date, is it within the year that the people allege? The year and 1 day. So I don't know what's difficult about that.
That refers to the conspiracy count. This is what...
It's true, it refers to the conspiracy count, but it puts you on clear notice as to when they're alleging a firearm was sold.
Sure, Your Honor. Well, 2 points here. One, what I'm arguing is that the count for first-degree sales does not effectively charge the crime alleged. There's a different...
Okay, so
there's
are
a different
you saying that
allegation
it doesn't allege the crime in that it alleges a year and 1 day, or is your further argument is that it doesn't include the sales?
It doesn't, because of the year and 1 day. It had to allege...
I'm sorry, repeat that. I didn't understand what you said.
It did not effectively charge the first-degree sales count because it alleged that the sales took place within a year and 1 day.
Okay, so stop 1 second, and then I'll get back to that. So you're not arguing that because under count, whatever it was, count 3, that where they're alleging the sale of the firearms, that because they don't independently list the individual sales that it's defective?
It's a separate argument. The first argument is the effective, whether the count the actual allegations in the count effectively allege that charge.
Assuming that this court is ready to accept or finds reasonable that the listing of the overt acts under the conspiracy provides you with sufficient notice as to the individual sales for that 1 year period, what is your argument then?
The notice, well, here's the problem. If you look at the Court of Appeals case on People v. Sangara, they say in that court explicitly, you cannot assume any acts that take place or are alleged in another count refer to the acts in discount.
Except it says specifically, he sold a gun to an undercover. So we don't have to assume anything. It tells us very clearly.
But not under discount. That's the problem.
Isn't that semantics?
No, it's not, Your Honor. They very easily could have chose different
He's
counts.
charged with criminal sale of a firearm and conspiracy, right?
Conspiracy to sell firearms, right? Yes. Right. So, I mean, that's my question is, or my question to you is, why is that not enough? You have criminal sale of a firearm with the dates, criminal sale of a firearm, and then you have conspiracy to sell firearms with the dates stated as to when he sold those firearms to the undercover.
Again, this goes back to Sangara. You're not allowed to just assume that those sales that are referred to in one count refer to another count.
So in your mind, the prosecution had to relist all 18 dates, the sale of 33 guns. They had to relist it on count 3 to make it applicable to the gun sale charge?
Yes, in a way,
That's absurd.
but this is also different from the allegation I'm stating. As I'm stating, the factual allegations in that.
Well, there's two arguments, right? That's another one. So your first one is
that's one argument.
The first one is that the year and 1 day. So them alleging January 6, 2019 to January 6, 2020, a year and 1 day, right? But doesn't that include the 1 year period that's required by statute?
No, Your Honor. Because it says a year and a day. You have to read it on the face.
Literally, the statute says no more than a year.
Yes. Okay. And so.
The indictment is actually a year and a day.
I'm sorry. Can you repeat?
The indictment actually outlines a period, a year and a day.
Yes, Your Honor.
And so, because of that 1 day, you're stating that it's jurisdictionally defective, and therefore those counts have to be dismissed.
Yes, Your Honor. This is very
Can I
similar.
ask you one question, one more? So if the indictment had included all the details of the 18 guns or the 18 sales in the criminal sale count, but still had stated January 6, 19 to January 6, 2020, your argument is still the same?
Yes, Your Honor, because it states the time period as morning.
So it's not just that there weren't the details of each sale, it's the fact that they blew the time period by a day that makes it jurisdictionally defective. Goodbye.
Yes, Your Honor. Let me, as an example, mention People v. Solomon. It's a case that's cited in the briefs. There, the allegations were sexual assault crimes against the defendant based on a complainant who was under 17 years old. And so the indictment and the factual allegations, they gave a brief date of birth that said that the complainant was actually over 17 years old. Yeah. And so the prosecution, they claimed, hey, this is a typo. And so we could just amend it.
But that's a missing element, right? Because you have to establish that the victim was a particular age, and they failed to do that. Here, you had to show that the gun sales happened within less than a year,
yes,
right?
But
No more than a year.
What I'm saying.
Right? No more than a year. Yes. But so granted that they allege a year and 1 day. But if you look at the indictment as a whole, and you look at all the covert acts, they allege 33 gun sales on 18 days, covering a span of about 260 days.
Again, I'll go back to Sangara, but the other problem here, if you look at the bill of particulars, if you're in terms of what the bill of particulars says for every listing of every act, it says refer to what's in the indictment as well. And the indictment has this range of a year and a day. So
we're
we
talking
don't know
about
if
two
that
separate
also includes
issues.
another sale.
I think that goes more to notice. I'm concerned more with the jurisdictional defect. Right. The jurisdictional defect is more so in terms of an element of the crime, right? And you're stating that the element of the crime is within 1 year, and they are a year and a day.
Yes, once the factual allegations in the count said a year and a day, this is contradictory to the 1 year element, and therefore it did not effectively charge that charge.
All right, you'll have time on rebuttal, because we could go back and forth for another hour.
Hey, I'm ready for it.
We're not.
I was going to say, we're not.
Good afternoon, Your Honors, and may it please the Court. Christian Rose for the people.
Counsel, the statute says no more than a year.
Right.
Your indictment says a year and a day. You blew it.
No, because of General Construction Law, Section 20. Well, no, for several
General
reasons.
construction law, what you're telling us to ignore January 6, 2019?
It's not ignoring it because
No, it's not counting it.
right because
That's
that's
a
how
30-30 procedure. That is clearly wrong. Because if you had a sale on January 6, 2019, you want us to count it.
I mean, maybe if that was the case, but I mean, I think that
Well, here's what happened here. The thing is that it's hard to sort of justify what the prosecution did, right? Because not only do you blow it by a day, right? But you start counting on January 6th when your first overt sale is March 28, 2019. So why do you do that? Who cares? But here we are, right? Here we are. So now you explain how you met the statutory requirements of indicating the element of no more than a year when you claim a year and 1 day.
So I think several ways, and I want to make 2 quick points. The first about the General Construction Law being that it's not ignoring the first date. The date of that first date that is what dictates the range. So if it was January 5th, then the range would be January 6th.
Arguing to us that January 6, 2019 to January 6, 2020, that's 1 year?
That's how we counted in 30-30 time.
This is not 30-30.
Right, but that's General Construction Law. Section
No, no,
20,
no,
which
no, no.
applies-
When we say a calendar year, we say January 1st to December 31st.
Right,
If you, I'm still talking. So if you say January 1st and we come back to January 1st of the next year, that is 366 days. That's a year and a day.
There's obviously different ways of talking about what constitutes a year. Our position, and it's not our only position, is that General Construction Law, Section 20, says that this is actually a year.
Anything
But
in the legislative intent or anything of the commentaries or anything with the statute which would suggest that 1 year is a calendar year, January to January?
With the criminal sale of a firearm.
That's what
Yeah,
we're
it should
talking
be
about, right?
it should be 1 calendar year.
No. Is there anything in the commentaries or anything in statute which states that that's how you should that's how you should interpret it? As
That's how you should
January to
charge it in an
Yeah,
indictment.
yeah.
No, there's nothing like that. But
Okay,
I
so
think
what's your next best argument?
Well, I first want to address the question like why it would be drafted this way, because I think that the reason it's drafted this way is just because this is sort of how you draft indictments in New York, right? You track the statutory
No,
language.
I-
I'm sorry.
No, I don't know. I mean,
No.
I know I've drafted indictments. I've never, and so see, we've never drafted indictments like that, especially when there was no sale on January 6, 2019.
Well, that's exactly my point. So if you'd let me finish my point, the point is that you track the
Counsel,
statutory
I'd be real careful how you talk to the court.
I'm just saying that when you draft an indictment, you track the statutory language, right? This is what I mean when you say this is how you draft indictments, right? You track the statutory language. If it says that, murder is causing, or, first-degree assault causing serious physical injury, you don't put in the indictment all the various evidence of what causes serious physical injury. You just say it's
How
serious.
many indictments have you drafted?
I've reviewed a lot of indictments, Your Honor. I'm an
How many
appellate
have you
attorney.
actually drafted? 0, right?
Right.
So again, if the first sale occurs in March, why are you starting in January? Why then do you not go from the first sale is March what?
28.
March 20th to whatever 1 year is into 2020?
I think that we're just looking at this backwards because what they do is they look at the last sale and they go back a year.
And that's exactly what you did. You went backwards as opposed to going forwards, and in going backwards, you added a day.
But
That would have been
problem with
fine.
going backwards.
It was fine to go backwards. You just had to cut it off a day short.
Yeah, I mean, I think that I don't want to get beside the point, and that really, if we're looking at, Iannone and his progeny, which is where these indictment cases come from, what you're looking at is whether the charging documents, which includes, like the bill of particulars.
Yeah, but your friend
satisfy-
stated that the bill of particulars apparently just refers back to the indictment.
No, it doesn't. I mean, what it does is, and this is sort of why the argument about the overt acts in Sangara is beside the point, is because the bill of particulars also state every single transaction that occurs, right? So we know from the bill of particulars, we know from the overt acts, every single firearm sale that occurs.
Counsel, I would agree with you that in terms of the overt acts and every single firearm sale, it's clear as day, right? It's clear as day. Does that save your error in charging a year and a day when the statute says under a year? No more than a year.
So I think that there are, and defense counsel is right that he's making 2 different arguments, right? One is just
One is jurisdiction and one is notice.
Well, I think he's also making a jurisdictional notice argument, right? That it's so deficient that he doesn't have notice that it's a jurisdictional error, right? Which can exist. But I think that we're all on the same page that he had notice of the crime charged here. And then the other argument is just whether it contradicts, whether the factual allegations in the indictment contradict essentially the accusatory section, right? Whether the January 6th, 2019 to January 6th, 2020 contradicts an element of the offense. And I think you just have to look at the cases that the defendant cites to see that that's just not how we look at whether something contradicts something. Right?
I think to be fair, I think that the cases that both of you cite, none of them are on point.
I think the cases that set out a clear rule, which is that you look at the allegations and the factual allegations in the indictment, you assume the truth of those allegations, and you say with no more, right? And you see whether, if those are true, and the accusatory section is like the crime you're charging, whether you actually are charging the same crime that you have in the accusatory section, right? So for the marijuana case with that counsel was referring to, you can have, or sorry, that was another case cited. You can have 5 grams of marijuana alleged for prison contraband, but that's not dangerous contraband unless if it's over 25, right? So you assume the truth of the 5 grams, and that's just not a crime. For the age, right, it can't possibly be true, both that the date of birth in the indictment is true and that the victim was under 17.
So is the statute's language no more than a year an element of the crime or not?
It is, but...
So if it is an element of the crime, do you not have to plead it in conformity with that statute?
And we did, and so what we did is...
We did if we accept your construction that we don't count the first day.
No, even besides that. Because it could...
Sorry, we can't besides that because it's a year and a day.
No,
so either I accept your argument that that first day doesn't count, or you're out.
No, so what I meant to say is that even assuming that that's right, that it is a year and a day, it's still okay because it can both be true and was true, right? That the conduct occurred between January 6th, 2019 and January 6th, 2020, even that's a year and a day, even if it's 2 years, and that occurred within a 1-year period. We know that from the Bill of Particulars.
So you're
and we
saying
also
we
know
can
that
look at the factual allegations and surmise from that it was within the year's time, and therefore you've satisfied the element.
And I think
Is that your argument?
That's one of our arguments. I mean, we lay out like 3 different ways that we can win in this case.
Yeah, so basically you're stating that although the statute says no more than a year, that somehow it could be 2 years, but so long as the sales took place within 1 year, it satisfies the statute?
The reason that the element is properly alleged is because when you reference the legal section, and the legal section is specific, that incorporates that element. It's not.
Yeah, but that's negated if you have a contrary factual allegation.
Right, but it's not contrary here because
it is, because you're not really standing here and telling us that less than a year is the same as a year and a day.
No, it's not the same. I mean, I know that I know that my red light's on, so I don't want to.
Trust me, I would have stopped you a long time ago if I wanted to.
Well, so I think that I think that this also benefits defendants. So, like, assume that a defendant sells 1 gun a month for 24 months, right? The way that the defendant wants to have it is that the way that you would indict that crime is you could only indict, 10 at a time, right? But how
that's kind of what happened here because there were sales in 2018 that weren't part of the charge.
Right.
So that is what happened here. What didn't happen here is you didn't write the right date span. That's all we got here. This isn't more complicated than that, counsel. But we've heard your arguments. You have 2 minutes, and just 2 minutes.
Okay, Your Honor. Just very quickly, the prosecution is trying to amend the factual allegations in several ways. As CPL 200.70 says, you cannot try to amend factual allegations for an element of the crime. Unless there are any other questions about the amendment, I would want to talk about the excessive sentence argument.
Go ahead.
Okay, so the 10-year prison sentence imposed was excessive because Mr. Holmes Austin's, this was Mr. Holmes Austin's first ever offense. He was a working person
It was
cleaning
the first ever offense, but it was a doozy, right? 33 guns, over 18 sales, over 2 years. He's alleged to have been the mastermind here. It's not an insignificant thing.
Yes, it's not insignificant. It was a stupid thing for him to do, and it is contemplated in the sentencing range that is in this charge, which is a minimum of 5 years, and he's getting double of the minimum sentence here.
This was a negotiated plea, though.
Yes, Your Honor.
Because he pled to an SCI, actually, right? Did he plead
No,
to the
he
S-
didn't.
No, I'm sorry, but it was a negotiated plea, right?
Yes, but as Judge Troutman has stated in the Court of Appeals, they easily could have just charged him with his first initial sale, and then he would have only been charged with a firearm sales.
33 guns from Georgia and other states?
Well, here's one of the things this court has to look at is the
So you
vast
get
disparity.
32 free sales?
I'm sorry.
He gets 32 free sales?
No, Your Honor. What you have to look at is this is a conspiracy with 5 different people, and look at the vast disparity between the
And so, as my colleague stated, he was alleged to have been the mastermind.
and as I've stated in my brief, like nothing shows he's a mastermind besides these conclusory statements that the people are stating. He had no control over his suppliers. The suppliers set all the prices, and they're the ones that forced him to, like, well, not forced him, but had him go
I'm
up and
glad
down.
you-
Yeah.
I like that. His suppliers of illegal guns. I like that.
Yeah, but if he
It's
was,
all on the
if he was
suppliers,
if he was
right?
a leader, if he was a mastermind, then he would be able to get these people here. And I do want to acknowledge that he is a hardworking family man. His family, his beautiful wife and children are here, as they have been throughout his lower court proceedings. And this is just this is a aberration from his normal character.
Yes, and the families are always the innocent victims in all of this. Thank you.
Thank you.
Panzer versus Epstein.
Good afternoon, Your Honors.
Last but not least.
Indeed. Jason Sorolnik on behalf of the appellant. And I've had the privilege of appearing before this court many times, but I don't think I've had the distinction of standing in the way of Your Honors after a long day of argument getting off the bench. So I will try to be brief, but this is a really important appeal on an order that threatens significant consequences for the life of my client, Mr. Panzer, who spent his life, his professional life, creating and building a business, one of the top cabinetry businesses in the country. And the order from the motion court here directs him to sell his entire interest in this company to the respondent, that he must do that.
Well, there was a whole process that preceded that order.
There
right?
was, Your Honor.
And your client engaged meaningfully in that process, selected one of the arbiters, one of the 3 arbiters, et
Your
cetera.
Honor.
So I don't understand.
Sure. So I think, let me address Your Honor's question, and then let me address the threshold jurisdictional question, which I think is also dispositive here. But let me just start with Your Honor's question. There was a process, Your Honor, and the process is very lengthy and a lot of steps. It starts with the shareholders agreement, but there was a settlement agreement that specifically tried to take the parties away from the process in the shareholders agreement. Under the shareholders agreement, Your Honor, there is no world in which my client would be forced to sell his shares without him agreeing to do so. He had the first option to buy. One of them could buy each other. He had the first option because he founded the business. The settlement
Paragraph 10 of the settlement agreement changed that.
The settlement agreement changed the process, but did not change that, Your Honor, and that's the key. That's why Section 30 of the...
Doesn't it say there shall be a closing?
It does, but Section 30 of the agreement makes very clear that under no circumstances is he going to be compelled to complete a closing without his agreeing to do so. If he decides to back out, there are consequences. He forfeits $1.1 million of premium, et cetera. But Section 30 says, and these are the exact words, if claimant and or respondent fails to perform his obligations as specified in the agreement upon the date of closing, here are the 3 things that happen. Number 1, the provisions of this agreement and the exhibits amended thereto are voided in their entirety. Your Honors, I don't think I've ever seen a provision like that in an agreement. The agreement literally says this agreement self-destructs if either party doesn't close. It goes on to specify additional consequences, which are not included in that self-destruction, including the forfeiture of the $1.1 million if my client's the one who backs out. But Your Honor's absolutely right. There was a process, and there was agreed to consequences if either of them on the date of closing decided not to go forward. The consequences, Your Honor, if the other side decided not to go forward, is that he was not permitted to pursue the prior claims that he had started in arbitration. Now, based on the court's decision, that did not happen. The respondent here was willing to move forward. The appellant was not. And so the consequences that apply are the $1.1 million forfeiture.
So I guess what this means is you say paragraph 30 allows your client to say, I'm breaching, and there's a breach, and then he doesn't have to deal with the rest of the agreement? I mean, what are we even doing
He has
here?
to deal with the consequences that were agreed
Like,
to.
what is the point of having the stipulation? What is the point of settling the case if that's what you can blow it up?
Well, Your Honor, I can
So
give
you blow it, wait, I want to know what happens now. So if we follow your argument,
Yes.
the deal gets blown up, your clients have to forfeit 1.1 as their penalty, right?
The premium,
And
yes.
then they go back to fighting again about which one takes over the business so that we could do this all over again?
No, we don't do this all over again, Your Honor. What happens after that is Section 30C. The claimant and respondent's rights, titles, and interests in the Fabuate entities are as existed prior to the execution.
What I just said. So you go back to status quo pre the discussion of buy me out, right? And we are back at the same place
But Your Honor,
to do it all over again.
Your Honor, we're at a slightly different place. You're right that we are back in the place where there are both partners and there's a shareholders agreement that has a process for the buyout, but that's the process that applies. That's what Section 30 says. If either of them, 1, 2, breach on the date of closing, then their rights are restored. If Mr. Epstein does not breach, he can continue with his arbitration claim that had existed prior to the settlement agreement. This is their agreement. They both entered into it. And
Under this, arbitrators are going to get very rich because you're going to keep on coming back until they get the response they want.
I think, Your Honor,
Well,
I
not
think
really, because then the other one could breach.
Right.
Well,
So
no,
this is a never-ending cycle.
To be fair, Your Honor, I don't think any more breaches are going to result in those consequences because the breach provision that we're talking about is in the settlement agreement. What they are restored to is the shareholders agreement.
Well, see, that's what I'm not understanding. This is a settlement agreement.
It's
It's an agreement. The parties agreed to this.
They agreed-
After, I forget how many months of negotiation.
Yeah, I don't think it was that lengthy, but yes, they agreed to it, Your
So
Honor.
why are they not bound by the settlement agreement?
They are, Your Honor, but they agreed to specific consequences that occur in the event that either of them breaches on the date of closing. That's what this says. I mean,
All right, let me hear from the other side. You're going to get another chance to come up.
okay, thank you, Your Honor.
Good evening, Your Honors. May it please the court. Y. David Sharp of Morrison Cone.
So does Section 30 say what he says it says?
No, it doesn't, for a couple of reasons. First of all, they're acting like it's a sole and exclusive remedy provision. And we know that in order for it to be a sole and exclusive remedy provision, you need to have those words in there, and Mr. Cerulli can't point to that. That's number one. Number two, a party can't use their own breach to effectuate an unwind of a negotiation like this. This provision, at the moment of closing, was designed to prevent Mr. Epstein, our client, if he breached, the consequences of him not putting the money with the escrow agent was he was stuck with Mr. Panzer, something he had been trying to unwind since he also was a co-founder and a significant producer of this business.
Now, both parties were represented by counsel?
Yes.
I don't understand why in any agreement you would have a provision that would totally render the agreement meaningless.
We wouldn't. That's exactly right.
So what other language is there? Because you say there's nothing in the language that makes this the exclusive remedy. What other language is there that tells me there's another remedy?
The fact that there is all the mandatory language of shall at every single stage, and the arbitrators had a full and fair opportunity to consider all of the arguments that were being made here by the parties. The arbitrators had the authority pursuant to Section 20 to deal with any issues relating to the closing. That was within the powers that the settlement agreement granted to them. If Mr. Panzer truly believed that he had an option, that he can simply lose as badly as he did with his party-appointed arbitrator, and even the neutral was the arbitrator that was suggested by his party arbitrator. He lost as badly as anybody could possibly lose, and then turn back the clock and simply say, all the 15 times that it says, there shall be a buyout, there shall be a closing. And when the arbitrators do very important acts by issuing an order, an issue that was contested. When shall the closing take place? And there is an order that says it shall take place no later than April 18th, when the final award specifically says that the buyout price shall be effectuated in accordance with...
So if paragraph 30 doesn't mean what your adversary says, what does it mean?
It means that if Mr. Epstein did not put the buyout amount that he was obligated to put in, right? He needed to put the money in escrow. Once there was a determination, if he did not put the money with the escrow agent, then he was in breach at the closing because he was...
Right, that speaks of one party. What about the other?
Right. And the design of the settlement agreement, and that's what the motion court is saying, it had a right to determine, and this is what was before the arbitration panel.
The value and the date of closing, right?
Pardon?
The value and the date of closing.
Valuation of the date of closing, and that the closing shall occur in accordance with Section 10. That mandatory language that goes forward. There could not be a breach by Panzer at the closing. That's the way this agreement was set up. And the reason I say that is because all of Panzer's performance was put in escrow. All of the assignment obligations, all of the releases, everything was signed by Panzer years in advance of him saying, I don't need to do this. There was no performance that was required by Panzer at the closing. Everything was self-effectuating.
So paragraph 30 only applied to Epstein?
At the closing.
At the closing?
The language where it refers to both parties allows there to be a breach before the closing by either of the parties, and those are the consequences because the language in Section 30, which is listed as a default, not as an exclusive remedy, says, if the claimant and/or respondent fails to perform his obligations as specified in the agreement upon the signing of the agreement and/or upon the date of closing. So there are two periods of time which we can look at who are the parties are able to do this. Up until the time of closing, you can have a breach by either of the parties. At the time of closing, the way this was set up to avoid exactly Mr. Panzer from crossing his arms, gluing himself to the floor and saying, I'm not leaving this business, there was no performance that was required from him. The issue relating to his wire transfer issues is an issue that simply came up by virtue of the amount of money that the escrow agent had to send, and they needed a verbal confirm from him to say, you know, I want my money coming here, and confirming that to the escrow agent who had the obligation to make sure that Mr. Panzer got it. The award of the final award and judgment covers absolutely everything, and most importantly, the final award did not vitiate any of the interim orders, and Mr. Panzer did not seek to vacate any of those interim awards. The final award doesn't make the interim awards go poof. In fact, it was incorporated into the final award. There shall be a buyout, there shall be a closing, all of those things happen, and therefore it was appropriate for the motion court to grant finality to the parties, to interpret the will of the arbitrators in accordance with this court's authority that it granted in Pine Street, and as a consequence of that, the award should be affirmed.
Okay, thank you. You have a minute.
Thank you, Your Honor. I just want to pick up where Justice Rodriguez had challenged my friend. That's exactly right. The provision says if claimant and/or respondent breach on day one or on the date of closing, or. That's what the provision says. Mr. Scharf is here testifying and telling you, well, that's not what was really meant.
He was arguing.
Well, Your Honor, I'm
Go ahead.
politely trying to suggest that he's trying to give you evidence. He's trying to tell you this is what was intended. And Your Honors, what he's saying is the provision really should have said if claimant breaches on the following date or if respondent breaches on the following 2 dates. But that's not what it says.
But doesn't his interpretation kind of make more sense?
So Your Honor,
in terms of, you know, the settlement agreement, than your interpretation?
I don't think it does, Your Honor, but I would step back for 1 second and first say, I don't think that an Article 75 special proceeding to confirm a final award of 4 sentences that say nothing about a buyout, a court has a proper record to answer Your Honor's question. There was zero testimony, zero evidence submitted about Your Honor's very question. And I think it's a good question. What makes more sense is potentially relevant, but there's no record because this is not a plenary proceeding. The court here was limited to one job and one job only. You look at the 4 corners of the award, that's TCR, sports, and the Cuttree case that Your Honor was concurring in, which says, does the final award, quote, mandate a specific action? If it doesn't, the motion court on an Article 75 is not permitted to require that action. The action that they are asking to mandate here is the closing of the buyout. Your Honor, Mr. Scharf told you that that's what the final award issued said. I know Your Honors are about to leave, but there is not a single sentence that says that. It says the opposite. They asked for that relief in their pleading before the arbitration panel. They asked for an order directing the buyout. The final award says that is denied. All relief that is not expressly granted in this award is hereby denied. So they asked for this very relief, and the arbitration panel denied it. The only thing the arbitration panel did is it said the price, which gets filled in the blank for the procedures set forth in the settlement agreement, is the following price. But the settlement agreement that says, here's the procedure. If there's a breach on the date of closing, then the parties are restored to their positions and you can continue with your arbitration claims, Mr. Epstein. So it's very clear that the Article 75 court didn't have jurisdiction, and there's a reason why it's hard to answer your Honor's question, Justice Weber, because there's no record. I can tell you I absolutely believe this is what makes more sense. It's definitely what the plain language says, but there's no record because it was an Article 75 proceeding. And the only thing that the court was permitted to do was confirm the award and direct specific actions that were mandated by the final award in the language of the Cuttree case from this court. I thank you for the extra time. And
you're welcome.